Hi, everybody. Happy Valentine's Day. Taking care of stuff today. So, uh, yeah, got a little bit of a late start. Sorry, I didn't really give any notice, but we are going to get day 21 going. Officially, it's really day 21 this time. There wasn't a snow day. So, we're actually legitimately going to do day 21. I promise. Uh, um, so let's, um, we'll get this going here. Michelle Troconis. Hope everybody's having a nice day. Did want to say the lovely future Miss Smart 2.0 for some of you guys out there. I did get a nice Valentine's Day gift from her. And it's nice little setup. Oh. Oh, is it upside down? No, it's right side up. So gotta figure out where I'm gonna hang it. Yes, isn't it quaint? The Fed got this. She probably got it from her little Fed supply shop they have at the bottom of the FBI building. But it still works. I still like it. It smells like the Hoover building. So I like it a lot. So this weekend, not sure what we're gonna have planned. I know we got a lot to talk about tomorrow night. Looks like Hannah Reed is going to trial next week. So it's part of the Rush shooting. So we'll be talking about that a little bit, just in case you guys were wondering. Yeah, she did have a pretrial today, and yeah, it didn't go as she planned. So looks like Hannah's either going to be entering a plea soon or she's going to trial. Is it next to Mulder's office? I don't know. That'd be funny, though. What does the flag say? It says tread on them. Instead of don't tread on me, it says tread. Was it only one-sided? Yeah, that's what I thought. It says, instead of saying don't tread on me like the rattlesnake, it says, it says tread on them. Tread on them. So it's the Killdozer, if you weren't sure what that was. So that is, well, there we go. All right, so we've got Michelle ready to go. They actually did day 21 for reals. So apparently a lot of happenings happened this morning in court, which is a good place for us to start. Is it a banner or double-sided? It's a real flag. It's double-sided. So, yeah, but here we go, guys. It is, you have that on your school laptop. All right. So, yeah, guys, when we left off, they had moved on from Pavel Gumeni to the computer guy who was showing about the phones, locations of all the vehicles, and the kind of like tying in where everything was showing up online and like where the phones where everything was logging into as far as Fotis Dulos was concerned. So I think we're getting to that point now of what more is going to happen. Folding is hard. Well, now I'm getting rid of the iron marks and the creases, so it's better. Yes, it's for real this time. So here we go, guys.
I would, to make this easier for the court, it would not be our intention with any witness that's coming in to talk about anything that was said by the
Now, it sounds like we're already in the middle of something, so they screwed up on the timing for us, but there's already a motion practice being argued, so here we go.
Children or anything about their health or what their therapists were saying or not saying. That was an area that, even if it might become relevant, we have no intention of delving into. So that's the easy part of dealing with Mr. Meehan's or Attorney Paoletti's concern. Or conversations that the children had with Mr. Meehan, again, not relevant. But without being able to get into either what happened in this report, the fact that Mr. Dulos in Mr. Meehan's office read the report with his lawyer, Mike Rose. They talked about it. There's already in the material, the forensic download, the Celebrite report, a fair amount of conversation between Mr. Dulos and his lawyer about how great things are going and what we're going to do now, et cetera, et cetera. So that hasn't been presented to the jury, but it's in as part of the report that was provided by the state. So then we get into, well, what's happening in the month before the disappearance of Jennifer Dulos? I don't know how the state could say, well, we won't talk about what happened. We'll just put in some observations of the reaction, where I'm precluded by virtue of the court's prior ruling of getting into what was happening during the course of this hearing. It's my understanding that Dr. Herman wanted to be paid, and neither the lawyer for Mrs. Dulos or Mr. Dulos were willing to pay him until he finished his testimony. So that's a financial dispute that has absolutely, again, nothing to do with my client. And I would argue really has nothing to do with Mr. Dulos either, if he were on trial. The fact that there was some apparent conversation between Dr. Herman and the lawyers is neither here nor there. But if we're going to get into any of these court orders, I would have to then get into the background of it, because it had nothing to do with Michelle. She was absolutely not only innocent, but had no involvement or no issue with either her or her daughter as to why the court required that Mr. Dulos have absent Miss Troconis and her daughter and her 12-year-old daughter at the time from interaction with the Dulos children during visitation. Again, I don't know how to get into that, how we can address that without getting into the underlying custody. And it certainly doesn't go to my client's state of mind under any circumstances. And I would submit that in the absence of Mr. Dulos, you couldn't get into his state of mind as to how he reacted to that. It was complied with. In other words, there was no sneaking behind, surreptitious visits with the children. That order went into effect at some point. And it is something that the state certainly has to prove my client's state of mind, her intent. And if we can't even get into it and that she had nothing to do with it, and the reasons why it was entered into, again, puts us in a decided disadvantage. I can't cross-examine based on simply the fact that there's this order and we can't get into where it came from and why and how it was elicited, et cetera, et cetera. That raises the second question about the actual report itself. Now, it's our intention to not put in the 88-page report, but it would be our intention, and there's an order by Judge Lowy from, I think, 2020 or 2021, I have it someplace, that gave me the report. It was just the state's had it since 2019. The police obtained it. The state had it, and it was order disclosed to me, but with an order attached that it was not to be otherwise provided unless in the absence of a court order. So it's in my possession. It's in Attorney Felson's possession, but nobody else's possession. But we intended to put in at least the conclusions as part in a cover sheet from Dr. Herman to show that this is what the orders were going forward. And the fact that there was dispute about that in a sealed proceeding, which we're apparently not allowed to get into pursuant to this court's order. The state wants to suggest that, well, it wasn't going the way that Mr. Dulos wanted it to go. But again, how do you do that without getting into what's actually happened in the sealed proceeding? I mean, how can somebody testify that they went into this proceeding and there was something that happened that we don't know about or we can't talk about, but at the end of it, Mr. Dulos seemed sad or he seemed despondent, he seemed angry, whatever it is that's going to be testified to, the way I hear, and that's why we would need a hearing on it. But my concern is it paints an incomplete picture. But more importantly, it's particularly unfair to my client because she knew nothing about any of that. She wasn't at that hearing. The only people apparently that were at the hearing were Mr. Dulos, Mrs. Dulos, and their lawyers, and Mr. Meehan, and maybe the judge, clerk, and a court reporter. Well, I know there was a court reporter because I couldn't get that transcript.
Well, the court is not persuaded that the history of the dissolution proceeding is relevant. There's already been testimony that there was a dissolution proceeding pending. There's already been testimony that Michelle Troconis was not allowed to be in the presence of the 5 minor children. The court sees the scope of the offer by the state to focus on Fotis Dulos' response to the report. There's already been testimony that there was supervised visitation. the jury is not unaware of the necessity, based on the testimony of the social worker, of the reasons for supervised visitation. The testimony was that he was not allowed to be in the house. He was not allowed to be out of her sight. So there's already the strong inference that there is a concern. So the necessity of testimony concerning whether Michelle Troconis could be in the presence of the children, in this court's view, is not relevant. What's relevant, according to the state's offer, is whether, first of all, Attorney Meehan had any conversations or was in the presence with of Fotis Dulos, and Fotis Dulos's response to the report, or his response, if there is any, to the fact that there was supervised visitation.
If I may just address a few things, Your Honor. With respect to one of the other aspects the state wanted to just reiterate is the phone call that Attorney Meehan had with Michelle Troconis in March of 2021 and Fotis Dulos as well. He spoke to both of them, and it was very apparent on that conversation, he will testify to this, that Fotis indicated that Michelle Troconis was going to leave him because of he was scared she was going to leave him because of the strain of this divorce proceeding and custody hearing. What I just wanted to just clarify with respect to the Dr. Herman report and the fact that he indicated he didn't get paid by Mr. Dulos for his testimony, he never returned. So Judge Heller, he never returned to be cross-examined. He never came back to court. Judge Heller ruled that that entire custody report was sealed and that his testimony was sealed because he refused to return when he didn't get paid. So the idea to put any kind of emphasis on the state's view or the defense view on that day and that custody report, it is completely useless because Judge Heller ruled it so. And that's where the state feels that that is why it shouldn't come in the state's view. It shouldn't come in cross-examination. The report wasn't subject to any kind of scrutiny or cross-examination because Dr. Herman refused to come back. It has already been a judicial determination on that report, and in the state's view, it's completely irrelevant. The time and length of this process, of the arduous, I guess, restrictions on Mr. Troconis, on Fotis Dulos, and the fact that it culminated in March in a phone call to the GAL from the defendant and Fotis Dulos expressing what can only be described as their desperation for this to end. Then the idea that it didn't end.
Okay, so they're talking about stuff in the civil case. And in the civil case, a guardian ad litem known as a GAL was appointed. Typically, it's an attorney, and that attorney is appointed by the court as a neutral party that will give the court what it views as the best interest of the child, and it makes recommendations. It's an attorney and a third party who doesn't represent mom, doesn't represent dad, because they all have their interest. And even in cases with children's services, there's a guardian ad litem because they represent the child. So they might have a different view than children's services as well. And every once in a while, if the kid's old enough and the kid doesn't, and the guardian's making a decision, and the kid's like, no, I want to go home to mom. And the guardian's like, no, I don't think that's right. The guardian then has to tell the court the kid needs a separate attorney who's going to advocate for the kid. Because now that guardian is now advocating for something the kid doesn't want. And you're not allowed to do that. You have to advocate for your client's wishes. So they're talking about the civil case. This attorney Meehan is going to be the guardian ad litem, talking about Fotis. And yes, and we're arguing about what can come in, what can't come in from that hearing.
Is very important. So that's why the state is very clear with respect to the hearing on the family side for the sealed order, as well as the actual report. It is not something that should come in by either party.
Yeah, Your Honor, I'm a little bit surprised because it sounds to me that Ms. Manning is in possession somehow of the contents of what happened in those sealed proceedings, because all I know is there was an email sent to Mr. Rose, to Attorney Rose, saying, I want to be paid before I return. This notion that he refused to come back, or what Judge Heller did in that sealed hearing, is news to me. And I don't know how she knows that, but I certainly don't know that. So I also find that I'm at its further disadvantage because it looks like the state has those documents that the court has precluded me from having. And I'm wondering if the state will admit that they have access to the contents of what happened at those hearings, because I sure as heck don't.
Excuse me, Your Honor.
First, before we even proceed,
Can
the
I
court
just
is going
address
to
that?
indicate that the discussions of the dissolution hearings in this court view, any evidence of the dissolution hearings are not relevant. Any discussion of what happened at any dissolution proceeding not relevant. What the court finds relevant for the state's,
Even if it's not relevant, if the state does have access to it, he has a right to see that discovery. Because it might be relevant. Because the court hasn't seen it either. But I get what he's saying. None of that's relevant. None of that makes it any more likely or less likely that Michelle Troconis was involved in helping cover up the murder. There's no probative value. But we'll see what he gets to.
case is the following, and the jury can draw any logical inference that it wishes. When did supervised visitation go into effect? And what was Fotis Dulos' response to supervised visitation? What was his response to the report? It should be that narrow.
That's actually a fair way of handling it and making sure it's fairly narrow. That's actually not a bad way to resolve it. He's telling them that's what I'm allowing you to ask, and that's it. So that is going to be his warning to the state.
Otherwise, we get into collateral matters concerning what happened in a dissolution proceeding, which then may lead to, well, what orders were entered concerning custody, visitation, alimony, child support. Not relevant. So what the court will do is grant or it's already granted the amended motion for order, but also grant the third party witness protective order with the following conditions. Any fact which may negatively impact the minor children in the matter of Jennifer Dulos versus Fotis Dulos will be prohibited. Any fact involving the minor children in the matter of Jennifer Dulos versus Fotis Dulos, which is subject to state or federal laws of confidentiality, prohibited. Any fact involving the minor children in the matter of Jennifer Dulos versus Fotis Dulos, which is subject to state or federal statutory privilege, prohibited. Any fact involving the minor children in the matter of Jennifer Dulos versus Fotis Dulos, which is subject to a court's sealing order, prohibited. We also have to take up, outside of the presence of the jury, the motion to suppress the defendant's cell phone. Now, this motion has been the subject of a previous motion to suppress. So in order for the record again to be clear, this court granted the defendant's motion to suppress the warrantless seizure of her cell phone. The state was able to obtain a warrant for that cell phone. So before we even proceed with argument, Attorney McGinnis, what the court is going to do is this. Of course, the court has made factual findings concerning suppression motions from property seized at Fort Jefferson Crossing in Farmington, Connecticut. The court is not going to entertain a hearing, an evidentiary hearing, where those facts, again, have to be elicited. So the court would just put on the record the facts that have already been found. And the court is just going to refer to its memorandum of decision first on October 2nd, 2023.
I'm terribly sorry to interrupt. I just want to be very clear about what this motion encompasses. The state is not seeking to introduce evidence of the defendant's cellular phone or its contents. What this motion has to do with is called detail records, Your Honor, from AT&T, the defendant's provider. In other words, we're not asking that the court revisit its motion on the warrantless seizure of the cell phone. This is an entirely separate motion with respect to AT&T providing records. So I just didn't want the court to have to read that into the record, because I just want to be very clear that that is not something that we're seeking to elicit. If I could just, because it is the defendant's burden in my view in this motion. So I just wanted to just be very clear. In 2019, on May 27th, the New Canaan Police Department executed a search warrant on AT&T for the defendant's CDR records to include outgoing, incoming calls, SMS messages, things of that nature, as well as cell site location information. In 2023, the state did a new search warrant for some of the same records, some new records related to the defendant's AT&T provider. And on December 6th, the defendant had an outstanding motion to suppress the 2019 records. And I indicated to the court that I was in agreement that that warrant wasn't supported by probable cause, and we had done a new warrant in the interim, and it would be those records we'd be seeking to introduce. So I just want the record to be clear. We are not asking the court to revisit any findings from the warrant procedure of the phone. This is entirely separate. It deals with her CDR records.
So Attorney McGinnis, would not the facts concerning the memorandum, rather the motion to suppress property from Port Jefferson Crossing also be included in that subsequent warrant? In other words, aren't the facts that the court found in its October 2nd memorandum of decision some of the same facts that are going to be included in the affidavit for the subsequent warrant?
I can't recall specifically the findings that the court made. I mean, I can provide a copy of the 2023 affidavit to the court if you would like to see a copy of that.
The court has a copy.
All right.
And the court was under the impression that because some of the facts are the same, that it would not be a judicious use of time for there to be litigation about those same facts.
Well, I certainly agree with that, but I don't think that the court, quite frankly, needs to make any factual findings or have an evidentiary hearing in the first instance, because this was a search that was done pursuant to a warrant. I'll be heard on that at the appropriate time, but I don't think that the court needs to have a traditional evidentiary hearing, because obviously the only way for a defendant to get an evidentiary hearing when they're challenging a warrant is through a Frank's claim, which they've made, and I'll be heard on that at the appropriate time as well. But I didn't want to interrupt the court, but we are not asking the court to revisit its memorandum from the warrant procedure of the phone.
Just, again, I agree with the fact of what Mr. McGinnis said. That is not about the warrant procedure of the phone. What this is, however, is about, and I believe that Mr. McGinnis has just not given the full picture to Your Honor. On May 27, 2019, there was a search warrant signed by Judge Blowy for this CDR, for the location data from AT&T from my client's family, not just her phone. There was some testimony about that, so the court would have to at least look back at that testimony from that hearing. However, the motion to suppress, which was granted by this court, and I think it's the 6th of December, 2023, was a motion dated March 16, 2020, to suppress the AT&T data. On the date of December 6th, this was a remote hearing, if I'm not mistaken, Mr. McGinnis stated to Your Honor, we agree that the May 27, 2019 warrant was issued without probable cause. And the state's position was the court did not need to then rule on it, but the court said, no, based on that, I'm going to suppress that evidence from the warrant. Now, Mr. McGinnis just says that he mentioned at that time, well, they applied for another warrant. I don't believe that was ever mentioned to Your Honor, ever. So we start with that as an issue, because I know that at one point, Ms. Manning said they were going to apply for another warrant, just like they said they were going to apply and did obtain another DNA warrant for my client in 2023, because I assume they thought it was possible the court would find there wasn't probable cause to take her DNA back in 2019. But since Your Honor didn't grant that motion, I didn't argue it to the court, because it was kind of moot at that point. DNA didn't change between 2019 and 2023. But it's important to note, Your Honor, that this motion, that this warrant, although applied to, went to Judge Golger, and the thing that's more concerning is they checked the box that said that this warrant was not presented to any other judge, or this, and I assume they're trying to claim that, so if you look at, I attached a copy of the, of their warrant, and I think it's page 9, I think. It says the undersigned has not presented this application in any other court or to any other judge. So their position is, well, because it was different affiance, they can misrepresent the truth and say, oh no, we're applying for this for the first time, and check the box. But if Your Honor looks at my motion, not only is this not just a facial challenge, but we would have to hear why they would falsely tell Judge Golger that it was not submitted to another judge. And if they're going to try and argue, which I would then refute in cross-examination, that, well, we were not the affiance, that was some other affiant, even though we're all working together on one case, it wasn't me personally, so I could swear under oath that this affiant didn't submit it to another judge. And I would just point out that I would argue that if not an outright falsehood, under oath is a deliberate, reckless, and or reckless disregard of the truth. But finally, I do make some of the same arguments about its overbreadth, the lack of specificity and all this stuff, which the court didn't have to rule on because the state conceded that the original warrant lacked probable cause. So here we are in the middle of a trial. I get a copy of the fact at, again, the end of December with a new document and discovery dump, literally on the eve of New Year's Eve, that now has the renewed CDR material. But the more important key aspect here, Your Honor, is that my research has shown that AT&T only keeps this data for 13 months. So that would have been erased sometime by mid-2020. So they have a burden now to show that this is an independent source. It would not otherwise have been destroyed. What I think they did is, since we didn't get a hearing on my motion until December of 2023, they applied a month or so earlier, maybe a month and a half or so earlier, getting those records. Didn't, to my recollection at least, did not mention, oh, we got it again, so we don't care. I don't believe they said that, Your Honor. I can go back and look at a transcript, but I don't believe that Your Honor was made aware of that fact. And therefore, they have the burden of showing that this evidence that they obtained was in fact independent of the tainted, suppressed evidence that Your Honor granted on December 6, 2023. So that's just this is not my argument yet. It's to point out the distinction, just to make sure that Your Honor is aware of what the record now is, where we are on this issue.
Attorney McGinnis.
Well, I was going to wait for his argument, Judge, because obviously it's my position that they have a burden. But I guess I do need to clear this up. I was hoping that Attorney Schoenborn would simply accept my representation that I did, in fact, inform the court. But I did get a copy of the transcript just on the off chance that he didn't. So I'd like to read to the court what I actually said and what the court said. And this is from the December 6th transcript. Attorney Schoenborn begins his argument on why he felt the 2019 warrant should be suppressed. And then I jump in and I say, if I could actually maybe short circuit this, Judge. The court, yes. Attorney McGinnis, just with respect to the March 16, 2020 motion, which as I understand it, deals with CDR records which were searched and seized in May of 2019. And so if that's the scope of the motion to suppress, what I can indicate to the court is that the state at this time has no intention of introducing evidence from those cell phone records from that particular seizure, because we agree with the defense that the search warrant did not set forth sufficient probable cause. However, we did do a subsequent, and you'll recall, Judge, I kept dropping footnotes in my memorandums indicating please pretend that this information doesn't exist because I didn't want it to influence the court's decision on any of the other motions, so we wouldn't have to go back and revisit it. But we did do a subsequent search warrant for those same records, which was disclosed to the defense. And those records were seized, I want to say, in October or November, but probably October, and those were disclosed to the defense. They're mostly duplicative of the records that were seized back in 2019, but it would be those records which we would be seeking to introduce with a new warrant, which we believe does set forth sufficient probable cause. The court, thank you. So as the court understands the state's stance, there's no objection to the granting of the motion to suppress on that which was seized in 2019 concerning AT&T records. Is that correct? Attorney McGinnis, yeah, I mean, we don't have an objection to that, Judge. We have no intention of introducing it, so I don't know if it's mooted out by that, but in any event, no. I mean, certainly I don't believe that that warrant established sufficient probable cause. And so I would know, however, the court wants to handle it, whether it wants to officially grant the motion or, by virtue of our representation, we have no intention of introducing those records. Either way is fine. The court, well, it appears to make a clean record for the court just to grant the motion. Attorney McGinnis, sure. So when Attorney Schoenborn stands here and says that the state somehow kept this information from the court, which I did see in his motion, and I was hoping that he would walk it back today, that is completely contradicted by the record. I did inform the court that we had done a subsequent search warrant and it would be those records which we would be seeking to introduce. And I also just want to correct the record on one other thing before he gets into his argument, which is that we turned over these records to the defense in November. They were picked up on November 16th by Audrey Felsen, one of the defense counsel in this case. And I said it on the record on December 6th. So this idea that he didn't know until January 2nd, Judge, I don't know where he's getting that from, because he was part of this exact same hearing. And again, I'm not trying to cast aspersions because I think the four of us would agree that there's a lot going on in this case, but I just want the court to be assured that I did not withhold this information from the court. I did alert the court. And if we can now move on to the actual substance of the motion, I'd like to be heard, because I think that, frankly, the court should deny their motion to suppress.
Well, let me just correct the record. He's correct. I looked at my notes. I didn't order this transcript, so he did say that on the record. So I do want to correct that he is that I misspoke when I said he didn't bring it up to the court. But the fact that just Your Honor understands, in November, what we were given is a 5 or 8 terabyte external drive that had thousands and thousands of documents, including the same material that had previously been given. It wasn't separate. Oh, here's the new set of records that are separately being sought to be brought in. It was not until I was given a report by their expert, which included the GPS information again. And that was an end of, right after Christmas, December 29th, I believe, that I realized that they were now going to again introduce these records. So I filed my motion. I know, by the way, there's a typo in the title of my January 8th motion. It says 2024 search warrant. It should say 2023. So I just want the record to reflect that I misstated the date of the warrant.
And Judge, just to be clear, we gave this to them in November, not the end of December. And this discovery that we provided to them is not terribly large, just from my review of it. I think Attorney Schiff, we basically gave it to them twice. Once we gave it to them in November, and then we gave it to them again at the end of December. So, and I said it on December 6th. So I think the claim, and as the defense conceded, Attorney Manning indicated that we would be doing another search warrant before we did it. So this idea of unfair surprise thing, I think is frankly unfounded, Judge. But I'd like to just, after they argue, I'd like to be heard on the substance of the motion, because I think that the court should, in fact, deny it, and we should be permitted to introduce the records that were seized in 2023.
Thank you. The court will hear from the defense on the motion to suppress the CDR record pursuant to the warrant.
Ooh, the court's going to allow it. Okay, interesting. He's going to allow the hearing.
They're essentially, and first of all, I don't think, I'm looking at my motion, I don't believe I use the word surprise anywhere in my motion. I'm looking at it right now, and I would note, I've obviously had these records since 2020, since I came into the case in sometime in 2020. So nowhere am I claiming I didn't know what the records were, but as of the December 6th ruling, I assumed that this wasn't even going to be an issue, so that I filed, however, this motion in January at the first day of trial after receiving the actual December 29th list of exhibits, if you will, that they intended to use, electronic exhibits. And that's what I'm basing it on, not that I didn't know what the info was. I submit, Your Honor, that we can, my motion is kind of comprehensive when it comes to different issues. Your Honor looks at the warrant itself. It even mentions the seizure of my client's phone in there, which the court had suppressed. They included that as part of their probable cause determination. But I submit that nothing in the affidavit itself, let's assume it was the first time they did this. Let's assume it was the first time they did it. Nowhere in there does it establish that my client engaged in any phone calls, text messages, or anything for that matter that would entitle the state to go through any of that material. Even this new 2023 warrant affidavit does not do that or examine, other than the same argument they made at the hearing where the court suppressed the phone. They would like to have the stuff because there's always information that's in there. So that argument was previously made. The state simply agreed. So I'm just going to incorporate my December 6th arguments with regard to the affidavit, so I don't have to restate that. But there are other issues here that are concerning to me. And the most important one is the fact that they checked the box saying it was not presented to another, this affidavit. The undersigned has not presented his application in any other court or to any other judge or judge trial referee. And that, in this case, it's signed by Nicholas Olivetti and Detective Jessica Janesk, who in paragraph 1 state they are part of the Western District Major Crime Squad. What's interesting about that is we now know, and we have testimony, that the Western District Major Crime Squad was involved in this investigation from at least May 25th forward. So therefore, whether or not the original warrant was signed by 2 New Canaan police officers, and now it's signed by 2 officers or detectives from the Western District Major Crime Squad, is neither here nor there, for the simple reason that it's a joint investigation. And there's the presumption that the knowledge of one, the collective knowledge doctrine would clearly apply here. It's not like they simply sent 2 detectives in and say, gee, you don't know anything about it. Why don't you apply for a warrant for this phone and pretend that nothing else exists? Because they obviously had that tainted information at the time that they applied for this warrant. So we start with that. They stated to Judge Golder, and I submit, Your Honor, that the whole reason that this is in these judicial forms is to alert the judge that another warrant was applied for, that another warrant was suppressed. And yet we're going to another judge. And I'll note, this is the 3rd time, I'll just say it on record, 3rd time that the state did this. The first time they did it involved after the death, and again, I have not made this an issue, but Your Honor needs to be aware. When Mr. Dulos committed suicide or attempted suicide in his house in Farmington, 2 affiants from the Farmington Police Department sought a warrant to search the house for evidence of a murder. That warrant was presented by Farmington Police with, as I understand it, in consultation with the state police to a judge in Hartford. The presiding judge at the time was, it doesn't matter. But the judge in Hartford. That judge declined to sign that warrant, refused. This was now 6 months, 7 months later, refused. So what did the law enforcement do? The state police represented it with different affiants, went down here with and
Judge,
went
I'm
to
just gonna-
Judge
I'm gonna
Hernandez.
object at this point to this, and I know it's highly unusual to object during an argument to the court, but this is really getting far afield from the issues here. And frankly,
Is it really? He's bringing up some points. Like, Your Honor, it's getting too far away from us not proving Michelle killed someone.
It's
Your Honor, I'd like to
untrue.
finish because I'm
It's-
putting on evidence of misconduct. It's not the first time, and that's why I'm putting this
It's
on.
untrue, however, that Detective Kimball and Ventresca were part of that initial search warrant in Hartford, and we've
Well, what the court has to do is, first of all, be alert to the arguments of counsel. When the court determines that the arguments of counsel are going far afield, then the court has to interject.
Yes, Judge.
What happened in Hartford may be of interest to the defense, but it does not hold sway with this court as to what it has to do in this case.
Well, it's the same. It's this case, Your Honor. I'm talking about the fact that 2 state police affiants went to Judge Hernandez, who rejected the warrant because those boxes weren't checked. They then, and it was Detective Butin and someone else who then checked the box saying this has not been presented to any other judge.
Well, the
So-
argument you're making, counsel, is that this has been done before. But whether it has been done before is not pertinent to what the court has to do under this set of facts.
I agree. And I'll limit the purpose, though, was to show there's a reason why there's that page inside a warrant, that it's to alert a judge to make sure they are not signing something that has already been ruled on in the case. And so the first thing that the state would have to prove is how they avoided that, what they did to inform Judge Golger that this is the first time it's being presented. Essentially, I think that's the reason for this, this to prevent judge shopping. That's the reason for this. So we have that. And then I did some research. The state's also going to have to prove that these records existed, because if you go to, and as I said, I don't have this burden. The state has the burden of showing where they got their evidence and that it was properly obtained. And I've already refused to agree to an affidavit from a records keeper, which is not the law in Connecticut. But these records would have been destroyed, or at least most of them would have been destroyed within 13 months of their creation in 2019. And the state's got the burden not only of proof, but that these records, in fact, would have existed outside of the fact that they had obtained them by virtue of a illegal, unconstitutional search, because it does involve privacy rights, and it does involve not only the Connecticut Constitution and the Fourth Amendment, which I cite, but it also cites the the Federal Electronic Records Act. That's 18 U.S.C. Section 2510. But and finally, Your Honor, I note that I did cite there's a recent Second Circuit case which asked the court to look at, United States versus Loria. It's a 70F 4th 106. It specifically says that if a warrant is applied for, and if a defendant makes a motion to suppress, pointing out the defects in the warrant, then the government, in that case, the federal case, cannot go get another warrant and argue either independent source or inevitable discovery. The Second Circuit as recently as this past year said that the Fourth Amendment does not permit that, because once a defendant points out the deficiency, they cannot simply turn around and get another warrant. So the burden is not on the defense to show, because they could just, why not, while we're talking, go get another warrant, and then I have to keep arguing ad nauseum, and it becomes my burden once again. So I submit to the court that the state has the burden, not only, I would have the burden if all we were dealing with was whether this warrant suggests probable cause or allows probable cause, and under both the Riley and Carpenter, the Galfin and the Mordowinitz case, Mordowdanec, it does not. But be that as it may, there are all these other issues that they have the burden before any evidence comes in. It's tainted evidence, regardless of the fact that they applied for the warrant, regardless of the fact that they, in my view at least, recklessly disregarded the truth when they told Judge Golger that this has not been presented in any other court or to any other judge.
Good morning, Judge. What a romantic way to spend Valentine's Day. Judge, no surprises. I disagree with just about everything that the defense said. And I want to begin with this issue of the state somehow has a burden of proof of showing that these records would have existed but for the previous illegal search. The defense is absolutely wrong on that. You'll recall, Judge, that we went around the block on that a few times when we were talking about the reasonableness of the execution of the search warrant. And one of the things that I pointed out to the court at that time, and I'll reiterate to the court now, is that it is actually the defense that bears the burden, the initial burden of proof of showing that there is a causal connection between the illegality and the evidence which is seized. And that comes directly from Wong Song, which is the United States Supreme Court case dealing with the fruit of the poisonous tree. Specifically, the defendant must establish the incriminating evidence, quote, would not have come to light but for the illegal seizure. So it's untrue to suggest that the state somehow has to prove that these records would have still been in existence. It's actually the defendant's burden to show that they would not have remained in existence. And I'll also direct the court to United States versus Oro, 2022, Westlaw 18155-665. Defendant bears burden of proving execution of search warrant was unreasonable and suppression not appropriate, where there is no causal connection between the unreasonable conduct and the items ultimately seized. There's a couple of other cases, Your Honor, that stand for that very proposition. But Mr. Schoenhorn simply standing in front of the court and saying, because of his research, they would have been erased after 13 months. Two things on that, Judge. One is that our research shows that AT&T holds these records for 5 years. However, they don't hold all the records for 5 years. So, for example, we lost something known as NILO data, which is essentially the phone giving a handshake with a particular cell phone tower to give location data. But it's actually the defendant that bears the burden of proof with respect to that, and they failed to meet their burden today because the evidence actually is that AT&T holds these records as a matter of course for 5 years. So that's point number one. But we didn't have to prove that. They had to prove that they don't. So that's point number one, and I'll just pick it up there. But I want to also indicate that there are 6 other reasons why this court should deny the defendant's instant motion to suppress. First, the defendant's failure to raise this motion sooner should be considered a waiver by this court. Now, under 41.4 of the practice book, if a party doesn't raise a motion to suppress in a timely manner, absent good cause, the court should deem their failure to do so a waiver. So just to address some of the specifics in their motion, the defendant writes that she was unaware of the fact that the state had done a separate search warrant for her CSLI records until January 2nd. However, that is simply untrue. We turned over a copy of the warrant and a copy of the records in November to the defense when we were still very much having motions to suppress. Additionally, the defendant writes in the motion, we've covered this a little bit, that the state withheld this information from the court on December 6th during the hearing. That is simply untrue, and I've already read you a copy of the transcript. So obviously, the defense was on notice of the fact that we were going to be introducing these records, and despite that fact, they didn't file their motion to suppress until, I believe, January 8th, or the day that we were originally slated to start trial. So I personally think that at this point, it should be considered a waiver by the court because they haven't shown any good cause as to why they didn't raise this issue sooner. Second, the defendant has no reasonable expectation of privacy in subscriber information or her toll records, nor does she have standing to assert that somehow a violation of her family's rights, which I don't even know how to get there, that she would somehow have standing. So
can the court just not interrupt, but just clarify?
Court can interrupt.
The court, on a previous occasion, denied a motion to suppress information gained from a tower dump.
That's correct.
Is this was not the argument that was made for that matter, but essentially there's no expectation of privacy in a tower dump. Is this essentially that argument?
Not exactly, Judge, because a tower dump, and you'll recall this when we argued it, a tower dump is a little bit distinct from somebody's individual CSLI records, their individual location records, because a tower dump obviously is simply a data download of any phone that hit that particular tower, whereas here they're actually pulling the defendant's specific CSLI records. And under Carpenter, if it's beyond a week, a defendant does have a reasonable expectation of privacy in those records. But that is separate and distinct from the fact that a phone call was made, the fact that a text message was received, the duration of the call. Those are just traditional toll records. And under Maryland versus Smith, 442 U.S. 735, there is no reasonable expectation of privacy in such records, nor is there a reasonable expectation of privacy in subscriber information, which incidentally didn't even belong to the defendant. It belonged to her mother and was obviously conveyed to a third party, being the phone company. So I think we also need to parse out their motion because, quite frankly, I think with respect to that stuff, the court shouldn't do a really long analysis of that because obviously there's no reasonable expectation of privacy with respect to the toll records. But if we get to the issue of was there probable cause for the cell site location information for the defendant, I would argue to the court that with respect to that, the current warrant is supported by probable cause and particularity, and the defendant has failed to meet their burden of proof. Namely, obviously, the defendant bears the burden of proving that a warrant is insufficient probable cause or not sufficiently particular. And the court knows from our previous litigation and its experience that there is a strong presumption of validity with respect to search warrants. And given the reasonable inferences that can be drawn from this particular search warrant that Judge Holder signed, Judge Holder could have reasonably concluded that the defendant was, that Jennifer Dulos was assaulted or murdered in her home, that Fotis Dulos and or other persons were responsible for that murder or assault, that the defendant, by accompanying Mr. Dulos to Hartford with bloody clothing, was an active participant in the disposal of evidence relating to that murder and assault, that the defendant had her cellular phone with her at the time of the disposal of that evidence based on the fact that her cellular phone hit a tower in the area. That was information that we got from the tower dump, which the court has previously denied. That this crime involved pre-planning, especially given that the body had never been found, and that the crime involved activity even after the crime as evidenced by the destruction of the evidence. And therefore, the defendant's cell site location information for both the week before and the week after produce a fair probability that evidence relating to the crime would be found, including potential phone calls and text messages and locations.
Ooh, we have a snow.
Including potential phone calls and text messages and locations, which might reveal where additional evidence of the crime may be found. And it's a very narrow time frame. You know, counsel in the motion, it's not just a typo as to the year. Counsel in the motion refers to the previous 2019 warrant when he refers to the scope. And he says that we asked for March 20th, 2019 through a date uncertain. That's untrue. The new search warrant specifies week before and a week after. And I would just direct the court to State versus Smith, 344 Con 229. They're involved in an even longer period. And even though the court ended up granting the motion to suppress for different reasons, namely that they didn't properly link that defendant to the crime, they talk about how that time frame was generally reasonable, and also the data which was sought was reasonable or likely to be reasonable under the Fourth Amendment. And so if you look at what we sought in this new search warrant, we greatly narrowed the time frame. Fourth, the defendant is not entitled to a Franks hearing in this case. To begin with, there is no false statement by either of the affidavits. The box which the defendant indicates should not have been checked reads, quote, "The undersigned have not submitted this application to any other court." The plain language of that box, therefore, requires two things. One, that the affidavits are the same, and two, that that specific application has been submitted to a court before. A plain reading of both applications show that one, the affidavit is different on the first warrant, and two, the application itself is different, both in terms of the amount of data requested and the information provided in the affidavit is greater and provides probable cause. Moreover, even if the court finds that that was somehow a misrepresentation of fact to the judge, which of course it was not, for the reasons I've already articulated, the defendant has failed to make a substantial preliminary showing that the misrepresentation or omission was necessary or fatal to probable cause, which is required under Franks. Accordingly, the defendant's request for a Franks hearing should be denied. Fifth, the instant warrant and data seized is admissible under the independent source doctrine. The defendant conflates inevitable discovery and independent source. They are not the same thing. And I'll direct the court to State versus Cobb, 251 Con at 338, which describes the difference between the two. Quote, "The independent source rule applies only upon proof that, in actual fact, the officers did not obtain the challenged evidence as a result of the primary illegality. The inevitable discovery exception assumes that the evidence was in fact obtained as a consequence of the primary illegality, but is invoked by proof that, hypothetically, if the officers had not engaged in the primary illegality, they would have nevertheless, although in a different manner, have obtained the challenge evidence. Here, we have proven that the independent source doctrine applies. And I would direct the court to State versus Joyce, which I really think is persuasive for this court, Judge, 243 Con 282. And just by way of background, Your Honor, in State versus Joyce, which the court is probably familiar with, the police had conducted a warrantless seizure of the defendant's clothing and subsequently performed a warrantless analysis of that clothing for accelerants. It was an arson case. And the defendant was ultimately convicted. The defendant appealed the warrantless search of his clothing, and the Connecticut Supreme Court found that the police should have sought a warrant in the first instance and reversed his conviction as a result. When the case went back to the trial court, the state applied for a search warrant for the clothing, and a new analysis was done on the clothing, and the trial court found that the new analysis was admissible because the search warrant provided an independent source to obtain the evidence. In order for something to be admissible under the independent source doctrine, the warrant must be supported by probable cause derived from sources independent of the illegal entry, and two, the decision to seek the warrant may not.
I mean, yes, the independent source doctrine is a valid thing, but just listen to the state. Like, we've already heard they got a warrant and then they realized they may have fucked up, so they went and got another warrant proactively. This guy's flailing right now, and I hate it when the state does this crap, and the judge, I don't think is buying it, but we'll see what he says.
Be prompted by information gleaned from the illegal conduct. Here, if the court conducts an analysis of the search warrant from last year, you will see that there is no mention of the previous results of CSLI from the 2019 warrant. Therefore, it is supported by sources independent of the previous warrant. Second, the decision to pursue this warrant on its face cannot have been prompted by the previous search warrant for two reasons. First, the police had an interest in her CSLI prior to knowing what the results would be, as evidenced by the fact that they initially sought a warrant in 2019 from March 20th through May 27th. Second, the records obtained in the search warrant was not prompted by the 2019 warrant because the records obtained from the data were never previously retrieved. The 2019 warrant ended on May 27th. This warrant goes through May 31st. Third, as illustrated in Joyce, there is nothing improper about the state seeking a subsequent search warrant for the same information if a previous search is constitutionally infirm. And I would argue to the court that here we're on even stronger grounds than Joyce, because in Joyce they conducted a warrantless search, whereas here at least the police did in fact seek an initial search warrant. Sixth, the law of the case doctrine does not apply. The defendant argued in her motion that the law of the case doctrine does not apply. However, this court's suppression on December 6th was limited to the 2019 records, as I just read the transcript. The court did not weigh in on the 2023 records at that time, and the court was very careful when it ruled that it was only granting the motion to suppress with respect to the 2019 records. So I think the law of the case doctrine, quite frankly, is not well-founded at all. The defense gave no case whatsoever to support their position that the collective knowledge doctrine somehow would necessitate the affiants basically misrepresenting to the court that they had personally submitted this exact application before. And just with respect to the evidence of her phone being seized, obviously that was a natural end date for the warrant, because obviously any CSLI after that would have been irrelevant. But I think even if the court were to excise that information from the warrant and its analysis, it would still find that probable cause is sufficient here. I also just want to correct, Judge Hernandez did not reject a warrant for CSLI, to my knowledge. He initially rejected a warrant for DNA. So when defense counsel says that he rejected a warrant for CSLI, that's just not true. And the case relied on by the defense in the federal court, I had a chance to look at it this morning, Judge. Two things on that. One is that, of course, Second Circuit is persuasive authority, but not binding on this court. But number two, that case dealt specifically with inevitable discovery. It did not deal with independent source. And as I've already explained, they're two separate things. Counsel kind of rolled in independent source in the course of his argument, but I did not see that in the case. I'm not saying it's not there, but I just personally did not see that this morning when I looked at it. So I think the inevitable discovery argument, quite frankly, falls on its face because we're arguing that this is an independent source. Does the court have any questions?
No.
Thank you.
Can you have a moment, please?
Yeah.
Thank you.
I just want to address at the outset the independent source doctrine. I'm going to give the court three cases, Connecticut cases on the issue. State versus Correa, C-O-R-R-E-A, 340 Connecticut 619. State versus Degerville, D-E-G-O-U-R-V-I-L-L-E, 41 Con App 772. And State versus Rogers at 18 Con App 104. When we're talking about the independent source, first of all, as a doctrine, the court in those cases, as in the U.S. Supreme Court case in which they rely, Murray versus United States, 487 U.S. 533, all state that this is that the independent source doctrine is a form of inevitable discovery, although slightly different, but the analysis is the same. All these three cases, however, note that it is the state's burden of proving that the evidence was, quote, genuinely independent, unquote, of the previous unlawfully seized evidence. So to the extent that the independent source doctrine applies, it is the state's burden, not the defense burden, to demonstrate that but for the prior illegality, these documents would not exist. Second, I am flabbergasted, is the way I can only describe it, that the state would actually stand up and have the temerity to tell the court that because these are different affiants, even though they're all working together, that therefore they could swear that it did not get presented. So all they have to do, according to what I heard the state say, is pass it on to a different set of affiants, change the name on it, re-sign it, and go to the judge down the hallway and pretend this is the first time that it's been presented. I find that argument shocking. I find it somewhat absurd, but that's one of the positions that they're taking. And I would assume that any judge in this building, once they discovered that fact, would be, I would think, certainly perturbed, if not outraged, by such argument if it was made in front of them. Be that as it may, Judge.
Okay, so yeah, guys, if you weren't aware, the Kansas City Chiefs, the Chiefs at their championship parade, there was a shooting. They arrested a couple of we'll cover it tomorrow night, but a couple of well, there were multiple shooters, so immediately it tells you one thing. Wasn't a white guy and it wasn't terrorism. It looked like it was a gang issue that got out of hand, and some gang members decided to have a nibba moment in public, and they wounded a bunch of people. So, yeah.
The fact that they resubmitted a warrant after they came to the state came to the conclusion that their previous warrant lacked probable cause still brings us back to the fact that they have the burden of demonstrating that this was an independent source and it was genuinely independent from the illegality. That's simply not the case. Their warrant talks about things that were obtained. Otherwise, it's a do-over. They can basically apply for a warrant, have 5 warrants rejected, just go to, as long as there's more judges, just go to different judges and keep doing it till they find one who will sign without being oblivious to the fact that it had already been rejected, the same information on an almost, I'm not gonna say it's the same, it is slightly different warrant affidavit to a different judge. That's, I submit, not an argument that should hold any water with this court. Second of all, going back to their original argument, first of all, phone data such as text messages, phone calls, etc., are not part of a cell tower cell dump that we had that hearing on with the expert. So the state saying not exactly is like really saying not at all the same, because the information that they obtained through the second warrant is the personal communications between the defendant, her family, her daughter, all the things that one has an exact expectation of privacy in. In State versus Smith, excuse me, in State versus Smith with the state sites, these are cases I argued to your court back in December, so I want to just incorporate by reference. I don't want to cite all the cases I cited then. I think Brown and Smith were 2 of the more recent Connecticut Supreme Court cases. There was specific evidence that the defendant used his phone during the course of a crime, and therefore there was probable cause that that specific information from the CDL would be, from the CDR would be relevant to the crime. Here, the state's not even making that argument. The warrant says, well, there's also, half the warrant is about what one might find in general if one goes through the phone service and the phone company. The claim about the family goes to overbreadth. This wasn't even just her unit. It's the entire family plan, which included her mother, I think, again, I don't want to, her daughter and herself. So they got all that information. So that goes to overbreadth. They didn't even say we only want the data as to her phone, but all of those phones. So once again, Your Honor, that just goes to the fact that it would be like in a warrant that says we don't just want to search the defendant's house, but in the same warrant, 3 or 4 other locations in the same warrant, just somewhere among them, maybe we'll find something. So that's the claim I made with regard to the overbreadth of the claim and lacking of particularity. So I submit that one of the problems with this also, if they're going to put this back in, this also requires, as I can see, there are at least 2, if not 4 witnesses that we would have to call back to explain what the nature of or certain communications that my client had during those 2-week period. And I just will note that the state has already submitted substantial evidence by showing where she was in connection with Fotis Dulos. This is kind of cumulative, unnecessary. We've already put in where Dulos was, and we know my client was with him at certain times. So beyond that, I submit that it's not only should be suppressed for the reasons I gave, but from an evidentiary point of view, it's cumulative and unnecessary.
Thank you. First, the court will go over some of the case law concerning the challenge to a validly authorized warrant. If a defendant seeks to challenge the legality of a search warrant or a seizure conducted under a properly issued and executed warrant, the defendant has the burden of proving the illegality. A search warrant, or rather a search executed pursuant to a valid warrant, is presumed to be valid. And the defendant challenging that validity has the burden to prove that there was no probable cause supporting the issuance of the warrant, or that the search was otherwise unreasonable. Now, the defense has indicated that it is the state that bears the burden of showing how that independent source developed, or when that independent source developed. The court cannot countenance that hypothesis because it is the defense's burden to challenge and prove that a warrant was not valid. There's no indication in the case law that the burden shifts in a validly executed, well, a valid search warrant, a burden shifts to the state to show how did it develop that independent source and when. Now, that independent source doctrine, to use a swimming analogy, is like a saving stroke, because it always begins with there was an illegal search by the police, there was an illegal seizure by the police, either because there was no probable cause or it was warrantless. The saving stroke is the independent source doctrine, and that stroke can only be used if whatever the fruits of the illegally seized items were are not infused into the affidavit for the new warrant. And the policy is essentially this: if the police, by way of their own misconduct, occasion an item or information to be suppressed, they have another opportunity if they can get a warrant that doesn't rely on anything derived from the suppressed item or the suppressed data. And that independent source establishes, along with other facts, probable cause. And one argument is, well, why should the police have another chance? Well, Connecticut courts have determined that the police get another chance because there's a balance that has to be struck. And the balance is between deterring police misconduct on one hand and allowing a jury to hear all admissible probative evidence on the other hand. In State versus Rogers, that is 18 Connecticut Appellate 104, 1989 case, the police entered the defendant's home without a warrant and secured the premises while a search warrant was being obtained. After obtaining a warrant, the search of the house yielded cocaine and cash. The court in Rogers then articulated the independent source doctrine, which is an exception to the exclusionary rule. And the court held the rule barring, that is the exclusionary rule, the use of illegally obtained evidence does not mean that the facts thus obtained become sacred and inaccessible. If knowledge of them is gained from an independent source, they may be proved like any others. The rationale for the doctrine is that the interest of society in deterring unlawful police conduct and the public interest in having juries receive all probative evidence of a crime are properly balanced by putting the police in the same, not a worse position than they would have been in if no police error or misconduct had occurred. So it's a saving stroke.
But if we want to make sure the police do things right in the future, punishing them ensures they will comply in the future. Huh, funny how we're not willing to do that. It's almost like we don't care. Sorry, guys. I didn't realize it. StreamYard killed the thing here. Hold on. We'll rewind it. I don't know what happened. But yes, the cops getting mulligans like this, I think, is bullshit. So I'll rewind it. We'll get a couple minutes back there. So we'll start from about here.
Admissible probative evidence on the other hand.
So
And state
I disagree with the independent source doctrine. If it's been suppressed, it should be gone. Why can't it be gone? What better way to deter the police than to make sure they can't ever come back? You know, yes. Basically, the poison fruit could still be edible as long as you blow the poison off. It's kind of bullshit. So,
versus Rogers. That is 18 Connecticut Appellate 104, 1989 case. The police entered the defendant's home without a warrant and secured the premises while a search warrant was being obtained. After obtaining a warrant, the search of the house yielded cocaine and cash. The court in Rogers then articulated the independent source doctrine, which is an exception to the exclusionary rule. And the court held the rule barring, that is the exclusionary rule, the use of illegally obtained evidence does not mean that the facts thus obtained become sacred and inaccessible. If knowledge of them is gained from an independent source, they may be proved like any others. The rationale for the doctrine is that the interest of society in deterring unlawful police conduct and the public interest in having juries receive all probative evidence of a crime are properly balanced by putting the police in the same.
yes, apparently there's no issue the society will tolerate having improper police conduct. I fucking hate this logic.
Not a worse position than they would have been in if no police error or misconduct had occurred. So it's a saving stroke. The court is persuaded by the argument that there's essentially no causal connection between what could be claimed as information gained from a warrant for which there was no probable cause found and the current warrant. The court is also persuaded that there was no false statement. There was no misrepresentation. The affiants were different. The information was augmented in that second warrant. And finally, the filing was untimely. We are in week number 5 of a trial. Typically, in most cases, and counsel are aware of this, there's no 2 or 2.5 month continuance or delay between the start of a trial and the hearings on a motion to suppress. That is what had to occur here. But the argument that, well, the police can keep going back and getting warrants where they failed previously, they would not have time under normal circumstances because the motion to suppress may even be heard right before the jury comes out for the first day of evidence. So the court is persuaded that the filing is untimely. In addition to that, the warrant set forth sufficient probable cause. So the motion to suppress is denied.
May I just put one thing on the record, Your Honor?
Yes.
This warrant was applied for on October 4th, 2023. This trial began on October 7th, 2023, when I believe it was October 7th, the jury selection. No, September, excuse me. I think we had jury selection in September. So therefore, the search warrant was applied for after the trial began. Under the practice book, a motion to suppress is only to be filed before trial began when the issue arises before trial. This was not the return on the search warrant, if I'm not mistaken.
Ooh, that's interesting.
I don't even know what the return date was on this warrant. But be that as it may, it was certainly after the trial had commenced, and the disclosure to the defendant was in November at the earliest. And so therefore, I would just take issue with the fact that it was, quote, untimely, unquote. They'd had 5 years to file this motion if they thought there was something wrong with it. But to put it on the defense after the trial starts, that I'm supposed to have filed it in advance of the trial, I think is not a reasonable conclusion. Your other honors ruling, I accept, but I want to just put on the record that I think that finding is not supported by the record in this case, that it was untimely.
Thank you. The court is going to take a morning recess. The state does have witnesses for today. And how many witnesses, Attorney Manning, and who are they?
Your Honor, I have one police officer who should be brief, as well as 2 lay witnesses and Dr. Gill from the medical examiner, which I think we need to address counsel's motion on that matter.
Would Dr. Gill be the last of the witnesses?
I believe so.
So the court will take the opportunity to take a look at the case law that is likely to come up with Dr. Gill's testimony.
And Your Honor, I know the state has indicated that one of the...
Okay, look, I love this judge, but that is not the right ruling. The judge, I think all judges should say the independent source doctrine is bullshit, and it's because we come to a point that Squizgar brings up. How are you doing, buddy? For $10. Thank you. Is saying the flaw in that logic is once the police know the evidence exists, they can't unlearn that. And they never get back to us that the misconduct doesn't exist. And that's true. The exclusionary rule should be meant to punish police. And you know what? Society has an interest in making sure its cops do things the right way. So when the cops start fucking cases up and the cases start getting thrown out, the public will then hold the police accountable and say, do your fucking jobs. You're not doing them right. Okay, we'll put pressure on our politicians who oversee the police and fire your asses and get cops who will do the things right. There's a system of accountability if the courts were to enforce it. The exclusionary rule should be a fucking death penalty. You fucked up. It's done. That's how it should go. So. That's how I would say it. So, yeah, thank you. Happy Valentine's Day, everybody, again. Yeah. He didn't lose all credibility. That's all how this every judge does this. So that's not. Yeah, how they get search warrants after everything started. That is bullshit. I agree. So yes, overall this judge is not bad.
Police officers that's going to testify is simply going to say they searched 61 Sturbridge Hill and found nothing. I'm going to argue that that's irrelevant and just using time unnecessarily. And therefore, since it's like the same as everything else that's been presented that shows negative evidence that is immaterial to this case, it's certainly immaterial to my client. And therefore, I ask the court to preclude it.
Well, the court would not know what the state intends to introduce. How counsel would know that, the court does not know. We will wait for the evidence before we rule if there's an objection.
Well, could I ask for an offer of proof with regard to that witness then?
What you're asking for, counsel, is this. You don't want to waste time hearing certain things. And if the state wants to call a witness and you think it's a waste of time, then the court should preclude it before the court even hears it. So that's denied. We'll stand on our recess until 11:45. The counsel would present the court with the case law that it needs to review.
Judge, there's another matter. There's I think a witness is being called for which a motion in limine was filed in January regarding, my guess is, the state's intending to put on a video clip through some witness about an unknown person wearing and it's literally a 2-second clip as far as I can tell, of a person in a navy or black sweater or sweatshirt riding a bicycle about a half hour away from the location of Jennifer Dulos's house. So I'm objecting. I have a motion in limine regarding that. There's certainly no foundation regarding it.
Oh, all right.
There's no
Yeah, it looks like there's another thing going on here, guys. So here we go.
correlation between any other evidence, and the court will recall that the only testimony about any bicycle was Mr. Gumieni saying that there was a light blue jacket inside a bucket that he put in the house. It's the only evidence about any outer clothing. So this is, in my view, an attempt. Well, the motion speaks for itself, Your Honor. And if Your Honor looks at it, because it literally is about 5 seconds or 4 seconds, unless the state has a different offer than what I've previously seen. They just literally, after the break, handed me the video, so I don't know if it's the same one. If I'm assuming it is, I object and I have my motion pending.
With respect to that witness, Your Honor, or Sergeant Pearson, who is about to
Oh,
go
well, the court
on?
did not know which witness was being called.
Sergeant Pearson is first, Your Honor, as to the search of 61 Sturbridge Hill Road. And then the state intends to offer evidence of Todd Holson, who owns 386 Weed Street. That's the subject to counsel's motion. Does Your Honor wish to hear that argument now or after?
The court would rather not have the jury come in for a short testimony and then leave, so the court will entertain the argument now.
Sure. Your Honor, with respect to 386 Weed Street, what I would indicate to the court, there has been more than enough evidence over the past month of the travel route of Fotis Dulos the day of, or the morning of, I should say, 5/24/2019. Specifically, what the jury and the court has heard is the Toyota Tacoma leaving 80 Mountain Spring at 5:35 in the morning, being on the Merritt Parkway, traveling, being seen on Route 15 at the Fairfield rest area, the New Canaan rest area, at 6:36 and 7:03. At 7:05, a New Canaan school bus passes Waveney Park area, and there is no Toyota Tacoma Park there. The reason why I start this way, Your Honor, is because the timeline is important and it makes this video extremely relevant. At 7:31 along Weed Street in New Canaan, a person on a bike is driving past the area. This is a route, Your Honor, from Waveney Park to 69 Wells. And the time of that bike ride is actually one of the most key parts of the evidence that the state wishes to introduce, because at 7:40, a school bus goes by and the Toyota Tacoma is seen parked on Waveney Avenue. So the fact that this is the path of travel from Waveney into to 69 Wells, the fact that there is a individual on a bike through that area is relevant as well. I say the bike because, as Your Honor will recall, one of the items that was taken out of Albany Avenue garbage was a piece of tape. The alternate side of the tape had a Tour de France imprint on it. On top of that, Your Honor saw photographs of the Toyota Tacoma traveling. The state attempted to elicit testimony. Your Honor refused to allow the witness to testify as to what was in the back of the car. However, the state is going to argue that that was a bike. What I would also refer, Your Honor, to is in the defendant's own third interview, which the jury will hear in the next couple of days, the defendant discusses the fact that she saw a bicycle at 80 Mountain Spring that day, that the bicycle was in the garage. She talks about the fact that it was Fotis Dulos's bike, that it was, I think she uses the fact that there were, he had the bike, it was surprising or something to that effect. I can't find the transcript in front of me now, but the idea of the bike is actually relevant in her own words. So the idea that we have a video of an individual traveling the path of travel from Waveney Park, where the Toyota Tacoma is seen, to the victim's residence, or Jennifer Dulos' residence, at the time frame appropriate in light of the distance travel in the morning, and a bike that the defendant references seeing at 80 Mountain. Pavel Gulmini testified that the bike was missing from the garage photographs already in evidence, so it does make it admissible. It goes to its admissibility, Your Honor. The weight the jury can give it what they think it deserves.
Very briefly, I think if Your Honor would just look at the one of these videos. This is what we're talking about, Your Honor, and I'm going to show the court just one. I could show you a couple. This is what the state. If Your Honor can just look at the screen. Is it on, Your Honor?
Yeah.
That's it right now. That's their best one. Okay, there's a couple other angles, but it's all the same. This is about a half hour away from the Wells Lane house. This person is obviously, there's another, I'll just show Your Honor, one of the others here. So the court understands what this is. So we have the camera The person already went by on that one. There it is again, Your Honor. Person wearing all black clothing. And this, I'm going to ask the court to pay attention over where the telephone pole is on the left. You see there's a person in all black riding a bicycle. That's essentially what the state's offer is. I'll note Mr. Gumieni did not identify any truck other than the one picture coming back from New Canaan. He was not even asked about any of these other red trucks as being his vehicle. The fact that Mr. Dulos owned a bicycle does not even remotely suggest that that's him or that has anything to do with this case. So it would be pure speculation and lack of foundation. And there's, I guess, one more. I'll just show the court so that the court has a complete background of what these videos are. So there's at some point, yeah, there's an individual, navy blue or black, riding along on a bicycle, and that was it. Mr. Gumieni stated that they found in the truck a light blue jacket. It was definitely not navy blue, and it wasn't dark blue or black. So the suggestion that the jury could speculate that this must be Fotis Dulos or somebody who is driving, that had been driving that truck is complete speculation. It doesn't go to weight, it goes to nothing. And to suggest that that bicycle, I mean, if you saw a person riding on the back of the bicycle with them, to suggest that maybe that's how the individual was transporting the Ms. Dulos, I don't know, maybe that would be a different argument, but this is what we have. And I suggest it has nothing to do with the case. It's pure speculation. This was one of the things that the warrant sort of just threw out there and suggested, but the warrant had suggested that the person was wearing a navy blue or black sweatshirt, that's what Mr. Gumieni had claimed, but it's not in fact what he claimed. So I object on that basis.
Well, of course,
It's prejudicial too.
thank you. The court has heard the arguments, and the court is able to determine at this point, or is not able to determine how the jury will receive this, but this motion in limine really goes to weight, because there is evidence of a bicycle, even though the court precluded the witness from indicating, the police witness, what was in the back of the Tacoma. That does not mean that a juror or jurors would not conclude that what was in the back of the Tacoma was a bicycle. There's the same route, there's the time frame, there's the tape, and there's the hooded sweatshirt, the color of which is not certain. So the motion in limine is denied. Bring the jury out, please. Good morning, ladies and gentlemen.
Good morning.
The state will continue presenting witnesses today. The state can call its witness.
Thank you, Your Honor. State would call Sergeant Jamie Pearson back to the stand. You can go ahead. Thank you.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Yep, Sergeant Jamie Pearson, JamiePearston.
Sergeant, you may be seated. Attorney Manning.
Thank you, Your Honor. Good morning, Sergeant Pearson.
Good morning.
Are you still a member of the Western District Major Crime Squad?
Yes.
Okay, if you could just briefly remind the jury some of your training and experience.
Yep, I attended the State Police Academy in 2008, where I was trained in various things, to include accident investigation, interview and interrogation, crime scene processing, photography, report writing, and such. I was then stationed at Troop G Bridgeport as a patrol officer, and later joined Major Crime in 2013.
And what is your current rank?
I'm a sergeant within Western District Major Crime.
In 2019, what was your rank?
I was a detective on the crime scene processing unit, which is known as the crime scene van
I'm going to draw your attention specifically to June 5th, 2019. Were you working that?
in New Canaan.
Well, that's
Who were
good.
you with in conducting that search?
There were various members of the crime scene unit. Sergeant Duva was there, Detective Riley, Detective Downs, Detective Hazen, Detective McGavin, and myself.
Was Detective Matt Riley still the evidence officer?
He was.
Okay. What was your role in that search?
I was tasked with assisting, so no primary function, but just in searching and assisting the unit as a team.
Could you describe the property of 61 Sturbridge Hill Road?
Yep, it was a single-family residence, like a colonial structure on, a fairly open lot. And the house was, I would consider it under construction still. It was not in a completely finished inhabitable state.
Were there any furniture or clothing inside of it?
No.
What about the outside of 61 Sturbridge? Can you describe that, please?
Yep, it was a sealed up home, so it had windows and siding and such. The lawn had been planted recently or, fixed recently. There was a driveway, a construction dumpster. There were some things in the driveway and in the garage as part of the construction phase.
Did part of your search involve not just the residence, but the outside of the property as well?
Yes.
If you could just walk through the process of that search and how that was conducted.
Yep, we began with scene photography, which is something we always start with. We documented the exterior of the home, the property. There was a driveway in front of the residence, as well as, accessing the garage from the roadway. We documented the grass area. There was a fenced area to the rear of the house, as well as a old structure, like a shed type building.
Did the search include, you mentioned a dumpster. Did the search include the dumpster?
It did.
How would you conduct the search of the dumpster?
We physically got in the dumpster and then systematically searched through the trash, removing large items to discover everything within.
Were those items documented?
Yes.
In what way?
We photographed the dumpster as a whole, and then as we pulled things out of it, we continued photographing them.
How long did the search take that day?
We began around 10:30. I think it was 4 or more hours.
And with respect to the search result, was anything seized of evidentiary value from the interior of the house?
No.
What about the exterior of the house, including the dumpster? Was anything seized for evidentiary value in either of those places?
No.
If I may just have one moment. I have nothing further. Thank you.
So as far as I understand, you found absolutely nothing that you see, right?
Correct.
And you went in that house because it was a place where you knew that an employee of Dulos had been in the critical time period. Is that right?
We knew that the house was under construction, and we believed it was a construction project of the 4 group.
And did you know that Pavel Gumiani had been in and about the property that day?
Objection.
Right.
Calls for speculation, hearsay, no foundation.
Well, the question is, did you know or do you know if an employee of the 4 group was in the house? Overruled.
Could you repeat, sir? I'm sorry.
Yeah, did you know that employee from the 4 group, Pavel Gumiani, had been in the house at or around the time of the disappearance?
I did not know that at the time.
So were you looking for information pertaining to the employee or for information pertaining to the missing person?
The missing person investigation.
And you didn't check into whether or not there was anyone who had been at the property that day during crucial times, right?
I did not.
Did you determine whether or not there was any video surveillance in the immediate vicinity that might show the property and who might be about it?
Objection. Outside the scope.
Well, the question really is, for what reason were you at the property to search? That's the question. And there has to be a reason, so the court will overrule the objection.
We were there to execute the search warrant in relation to the missing person.
My question was, did you check to see if there might be any video surveillance that would cover that property that might help in your search?
On the property, there was no surveillance located.
What about across the street?
I did not conduct any neighborhood canvass, for lack of better terms, on that road.
Did
Just
anyone you were with do that day?
not on the 5th, no.
All right, so it wasn't part of your team that went into that house.
Correct.
And subsequently, did you learn that there was surveillance or not?
I did not.
I have no further questions.
Just briefly, Your Honor, if I may. Sergeant Pearson, you're a member of the van, is that correct?
Yes.
And were you a member of the van in 2019?
Yes.
Were you part of the criminal investigations unit?
I was not.
Thank you. Nothing further.
Is there a recross? Sergeant, you may step down. Thank you.
Next, Your Honor, the state would call Cedric Candotti. Thank you. I may have a moment, Your Honor.
Also a member of Fake Taxi.
Sir, if you can take that stand.
Okay, no, you don't come in wearing your pea coat and everything. Take off your jacket like a normal fucking human being. This is slobbing.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury? Please state your name and spell it for the record.
Cedric Candotti. Cedric Candiotti.
Sir, you may be seated. Thank you.
Your Honor, may I approach the clerk and just mark a few items? Good morning, sir.
Good morning.
Mr. Candotti, by whom are you employed? Who do you work for?
Russell Speeder's Car Wash.
Where is Russell Speeder's Car Wash located?
265 West Main Street in Avon, Connecticut.
And how long have you worked for them?
This year will be 14 years.
What type of business is Russell Speeder's?
It's a car wash detail shop.
And what is your current role?
General manager
How long have you been the general manager?
since 2013.
Was that always at that West Main Street location?
Correct.
And as a general manager, what are some of your duties and responsibilities?
Basically, overlook the allocation, in charge of payroll, operation, make sure equipment, labor is everything up to speed.
Were you working as or in that capacity in May and June of 2019?
Correct.
Your Honor, may I just have a moment?
Yes.
Your Honor, with respect to states 135, 136, 137, 138, and 134, absent any objection, the state would ask to move those into evidence.
No objection?
I just wanted to, I may have miscounted. Can I just see, look at it again, make sure I'm talking about the same.
Yeah.
Oh, yeah, got it.
Okay.
Yeah, no objection.
Thank you.
States 134, 135, 136, 137, 138 admitted as full.
Thank you, Your Honor. So I'm going to ask if you can just take a look at the screen right behind you. I'll show you what's been marked as 135. Okay, sir, do you recognize what's depicted on the screen?
Yes, ma'am.
What is it?
That's the car wash right there, Route 44, community parking lot.
If you wouldn't mind, Mr. Candotti, can you stand up at the screen and just point?
Absolutely.
Thank you.
This is the car wash itself.
For the record, he's pointing to the middle part of the photograph.
Correct.
Thank you. And the road up on the top, what road is that?
Route 44.
Is that also West Main Street?
Yes.
And the parking lot with all the cars on the bottom right-hand corner, do you see that area?
This area here?
Yep.
Yes.
Is that where, or what is that
Watch
area?
it.
If you could just explain it.
So this area, it's for detailing vehicle for customers.
If someone were to come into the car wash to get their car washed, where would they enter?
It will be right here. The first interaction will be with a customer service advisor. Then when it's done, the customer will drive up all the way to here, which is the main entrance, drop off the vehicle here, and go into the actually cashier, which is sitting inside.
And if somebody were to purchase more than just a car wash, does Russell Speeders have other things besides just a straight car wash?
Yes.
Okay, well, before I ask you that, where would they go to do that, to make that purchase?
So the same drill, customers pull all the way to here, talk to the customer service advisor, leave the car here. Depends the service the customer's having. The car actually travel through the building in the wash. There's another crew out here who finish the job. And if it's a detailing service, there's associate drive the car all the way to here, which is the detailing area.
I'm also going to show you states 137. If you can, sir, take a look. Is Russell Speeders depicted on that map?
Right here.
Okay. And you indicated the road above that, Route 202?
That's yes, that will be 44 or Main Street,
West Main Street?
West Main Street.
Thank you. I'm going to show you states 136 if I can. All right, well, I'm going to move this a little bit, just up and down. If I can just have a moment, Your Honor. Do you see the car wash on that?
Yes, it's all the way up here.
Okay, and that would be the Avon area?
Correct.
Okay, where would be the Hartford area in relation to this map?
Hartford, it will be towards that area, to the right.
And Farmington?
Farmington, it will be also, I would say this area too.
Okay, thank you. You can have a seat, sir. Thank you. So I'm going to ask you a question about May of 2019. Did Russell Speeders in May of 2019 have video surveillance?
Yes, ma'am.
Did that video surveillance, well, withdraw that. In August of 2019, did the Connecticut State Police come to Russell Speeders and ask to review that video surveillance?
Correct.
And did you provide or allow them access to review that footage?
Yes, ma'am.
How many video systems did the business have at that time?
There were two systems. One was a Lorix, it was an update. And then we have another one, it was a PC surveillance system.
When the police came to Russell Speeders in August of 2019, were you able to pull up any footage or video surveillance on that Lorix system for May 29, 2019?
The Lorix, unfortunately, didn't have any records on it. They have enough memory.
But what about the PC?
The PC, yes.
So with respect to the PC video surveillance, what areas or how many cameras did that system hook up to?
We have multiple cameras sitting in the whole car wash, and one of them is in the beginning of the entrance of the car wash. We have another one sitting on top of the customer lobby area, outside the car wash as well, in the detail area as well too.
So I'm going to ask you some specific questions with respect to the outside of the building. Is that okay?
Yes.
Okay. Where were the cameras located in the exterior?
In the exterior area, there's cameras located right in the entrance of the car wash before the car goes in the wash. There's another camera that are sitting in the back of the car wash when customers, you can see when the car is coming out of the tunnel.
Was the time accurate for those cameras?
For the PC camera?
For the exterior cameras?
Oh, the
ones
exterior
that-
camera, there was an 8 minutes delay, I believe so.
Okay. What about the interior of the business?
The interior, the same thing.
Okay. By the way, when you spoke to the police, did you give them a statement in 2019?
Yes, ma'am.
And did you have an opportunity to review your statement prior to testifying today?
I do not, like,
Okay.
barely.
Well,
Oh, I'm sorry, yes, I did that.
you did, okay. I'm going to ask you specifically to take a look at, if you can. States 134. And play file 1, exterior cam 529, 911. Sir, I'm going to ask if you can just take a look at the screen behind you. I'm stopping it right at 1 second. What are we looking at?
That's actually the entrance of the car wash.
Okay. Where would the car wash be located if you're looking straight on to the left or the right?
That, in terms of,
Well, if, well, I'll withdraw it, and I'm just going to play it if I can, sir, if you can just take a look. And the time down here, 9:11, is that accurate?
yes, so that's the camera have a little delay.
Yes, this is the Toyota with the forward seats. This is the one that had the forward seats ultimately. This is the one that had all the blood marks on the inside. They couldn't actually get blood tracks out of. So, and that's Powell Goodmany right there, I think. That's what they were saying.
Okay, sir, is that video taken from Russell Speeder's car wash on May 29th, 2019 at around 9:11 to 9:15 in the morning?
Correct.
Play clip file 2,
You're
interior.
right. That's Fotis at the car wash. My bad.
If you can, sir, just explain to me what we're looking at here.
That is the customer lobby.
And is this at 5/29, 2019 at about 9:05?
Correct.
Okay. Is this the camera that's 8 minutes, 7, 8 minutes low?
Yes, ma'am.
Okay. Okay, sir, I'm gonna play file 3, labeled exterior cam. Sir, if you could just explain what it is we're looking at here, and I'll just hit play.
That's a exterior camera that is pointing to the exit of the car wash. It's actually pointing when the car is coming out of the tunnel. And there's a crew that drive off the cars and do interior windows.
So at this screen, it says the bottom left-hand corner, do you see that? It says 5/29/2019 at 9:21. Is that time accurate?
Yes, ma'am.
At this point in the location of that camera angle, did the vehicle already go through the car wash?
Correct.
Okay, so what is happening now?
As of right now, as soon as the car coming out of the tunnel, there's a small crew that start drying off the car, doing windows, a little dusting off of the interior. That would be for a normal service, like quick service. But if the car need to go to the detail area, they drive them off regardless, and they bring the car to the detail department.
So if it was just the initial car wash, about how long does that take?
That for a quick service is only about 20 minutes, but a detailing takes up to 4 hours, could be.
I'm gonna stop the video at 1 minute and 35 seconds. I'm gonna show you one more video. Sir, file 4. Sir, what time is depicted on this video screen, please?
It looks like it's 2:28.
Okay, and 5/29?
But yes, ma'am.
Okay, so that same day?
Yeah.
I'm gonna hit play.
Yes. Did Fotis leave a tip? Yes or no?
So you talked briefly about the initial car wash. What are some other services that Russell Speeders provides?
We provide full services that include the outside wash, interior vacuuming, windows clean, wipe down
You
dashboard.
chop up your ex-wife's
Those service
body.
takes about 20-25 minutes. And also we offering detailing service.
What would some services that would be included in the detailing services?
Detailing service, basically all interiors. We break it down the interior of cars on 3. Basically, could be shampoo the carpets, seats shampoo, or dash door panels and console cleaning.
So there are 3 specific interior services.
Correct.
When you're utilizing one of those 3 services, do you use any cleaning products?
Yes, ma'am.
What are the cleaning products that you use?
We use all-purpose cleaners, spot carpet cleaners, and shampoo.
Is that for both the seats and the rug and the carpets?
Correct.
About how long does it take to do the car wash in an interior service?
I would say maybe like 2-3 hours, depends on conditions.
If I may.
Well, when you think about it, this should be a testament to how good this car cleaner guys are. They clean the cars so good the forensic people cannot find blood to test. That's how good they are at cleaning. We clean your car so good nobody can tell you murdered anyone. Trust us. That's a pretty good recommendation.
So I'm going to show you what's marked as states 138. What is it? What are we looking at right here?
There's a detailed log sheet. Basically, we use every customer who using or having a detailed service in a car wash, we take it down, name, phone number, detail, or what kind of car, the timing, and pricing.
Now, you mentioned the word full service before. What would a full service car wash and detail include?
full service is just a quick interior and outside wash. Full details, there's a different service that entails the whole day in the car wash because we go by appointments on that one only.
If you were to do a full detail service, would it be documented on this sheet is that what full means under detail?
Correct.
And you indicate that has to be by appointment?
That's correct.
What time do you have to drop off your car by that point?
In between 8 and 9 o'clock.
Now, I'm going to draw your attention over here to, if you could see the pen, the phone number. Putting here 305-331-5232. Sir, who writes that phone number?
The cashier inside.
Where do they get that information from?
From the customers.
And if we follow along, this one is blank. Why would that be blank?
It could be many reasons. The customer was in a rush, didn't give it time to give it the
I'm going to object
information.
to speculation.
Well, what the witness is testifying to is what the reasons are for not giving a number based on his experience. Overruled.
It could be for customer don't want to give it to him, or was in a rush, or didn't pay it at the moment, and we couldn't record it at that point.
And over here on this side, it's highlighted. Why is that?
That's kind of like the cashier highlighted just in case I go over the detail log and I didn't see a name. So she put a highlight that give me like excuse that the customer didn't provide information.
So the highlighting would mean that the customer didn't provide a name.
Correct.
Now, the time, what does that mean?
The timing, it was when the customer approached into the front cashier.
And this one reads 9:14. Would that be 9:14 in the morning?
Correct.
Now, we get over here and we have ×2. What does ×2 mean?
So that will be the combination of the service that the customer requests. Like I say, we break it down in 3 services so the customer can pick up what service they want.
Okay. By the 3 interior services?
Correct.
So the ×2 would be which of those 3?
It could be in between carpets or upholstery, or it could be dashboard console or carpet, either way.
By upholstery, you mean seats?
Seats, correct.
Now, down here two rows, I should say, is the DDC. What does that mean?
Dash, door, console, and clean.
So that would be only one of the 3.
Correct.
Now, above this reads full and then $250. Is that the price of a full service
The full detail.
and full detail? And is that the one that has to arrive before 9 o'clock?
Correct.
Over here on this last column, it says needs to pay under price. What does that mean?
The cashier, as a friendly reminder, because we don't request to pay up front, so we give you the option, the customer can pay when the car's ready for pickup.
I want to go back over to the name column and then the phone number column. The phone number is the same for both of these rows. Why is that?
I believe
Well, I'm going to object to speculation.
Okay, well, the court is going to allow the question. However, the response, the witness's response is, I believe. The court therefore will ask that the question be rephrased, such as, do you know the reason?
I will, Your Honor. Thank you. Sir, do you know why there is 2 phone numbers on, or the same phone number on both those columns or rows, I should say?
I don't.
Okay. And when we talk about the ×2 detailing interior services, what kind of equipment or process is that interior going through with those interior products?
So we use pneumatic tools for brushes. We use carpet brushes. We use all-purpose cleaners, spot carpet cleaner, dry shampoo, in vacuums.
And vacuums?
Yes,
Okay. And is that through the entire interior of the vehicle?
correct.
I may just have one moment, Your Honor.
Yes.
By the way, just one quick question. There was no name given on the detail log. Do you know whose phone number it was on who belongs to?
I do.
Thank you. Nothing further.
Thank you.
If I could just have one moment, Your Honor, perhaps, Attorney Moran could.
Two, no?
Computer problem.
I want to start, sir, with, just going to ask you about this detail log that you just testified about. To be clear, this is filled out by the employee, correct?
That's correct.
So if we were to connect this detail log to the videos that we just saw, it would be the young woman with the dark hair who was behind the counter who would fill this out.
Correct.
And the time that's indicated would be the time the vehicle that got brought in, correct?
Correct.
So the fact that there were, looks like that day, there were several Toyotas brought in, correct?
Correct.
There was one at 8:06, a Camry, right?
Correct.
There was a Toyota at 8:09 that doesn't indicate a name or a phone number, correct?
Correct.
And then it looks like there's a Toyota, maybe a Sienna at 8:44, correct, at the time, correct? Yes?
Correct.
And then they sought that $250 would be the full detailing, correct?
Correct.
Now, it's my understanding that when you come into the line, and I'm just going to go back to, you were shown this video, this picture, Exhibit 135. So in order to enter the Russell Speeder Car Wash, you have to come in from Route 44, correct?
Correct.
And you have to, this is all, in order to get to Russell Speeder, this is all blocked off here. You have to come into the large shopping center parking lot, correct?
If you're driving, yes.
That's true. If you're driving, you need to come in to the shopping center parking lot. You just can't walk into the area where the car wash is, right? And you have to go all the way down to a stop sign that's down in the parking lot of the shopping center, correct?
Correct.
And so that we're clear, even in 2019, this is a Walmart shopping plaza, correct?
That's correct.
And in addition to Walmart, there's also other stores and maybe even a restaurant or two next to the Walmart, correct?
That's
I
correct.
think there's even a Five Guys Burgers and Fries there, right?
That's correct.
So this is one of the entrances that everybody has to come in, right?
Correct.
And then there is, you have to make a turn. There are a couple of stop signs in order to pull into Russell Speeder. You then have to pull into one of these lanes that I'm pointing to that goes up to the entrance, correct?
That's correct.
And there's this express lane is on the right. Is that right?
That's correct.
And then there's for the rest of us, non-special, if we don't have our special badge or our free car wash pass, we have to get in the left lane, right?
That's correct.
And the video that we saw was from that left lane that the public that doesn't have express wash has to go in, right?
Correct.
And the camera, as I understand it, is right here, right before you pull into the building, right?
Correct.
And it's your custom, is it not, that everyone pulls up, the driver and the passengers have to get out of the vehicle at that point?
Correct.
And then when it drives into the building, that is employees of Russell Speeder that bring them in, right?
That's correct.
So when we see the vehicle move past the camera into the building, that was an employee doing that, right?
Correct.
And the individual that we saw get out of the red pickup truck was wearing like a suit with a dress shirt, correct?
That's correct.
And then you see that individual move off the camera. I don't want to play it again. I could, but they move to the right off that camera, right?
Correct.
And there's a door right here, is there not, to walk into the office just before the car gets pulled into the into the car wash, right?
Correct.
And it's one of these where it's on a conveyor belt of some sort, correct?
Correct.
You then have employees inside that either wash the car, you've got hoses, you've got brushes, and then it's somewhat automatic, correct?
Correct.
You even have some, if I recall, some animatronic, like mannequins that shoot water and stuff in your place, right?
Correct.
So the individual walks into the building, and I could put up that video, but I just want to see if, without doing that, if I can sort of picture, there are places where people can either watch their vehicle go through, it's all glass, right?
That's correct.
Or there are chairs, somewhat comfortable chairs, so they can sit and wait, correct?
That's correct.
The customer service or the cashier is down at this end of the building, correct?
That's correct.
So when we saw the interior video image, that is close to the exit that's over here, right?
Correct.
And the camera that showed the vehicle being pulled out is somewhere, I don't know exactly, but it's somewhere shining down on this part of the lot, right?
That's correct.
And that's after the vehicle has gone through the car wash and is now outside, right?
Correct.
And then you have employees that are wiping down the water, and they may even be doing the interior, correct?
That's correct.
And when the vehicle is then completed, either it then gets brought over into these parking spots for detailing, or the person drives out and goes on their way, correct?
Correct.
By the way, let me just show you this other picture. So exhibit 137, I asked you this, but I just want to be clear. So if this is Russell Speeder right here, the Walmart and these other stores are basically in the same parking lot, only further to the south of Route 44, correct?
Correct.
And there's a clear line of vision, if you will, to the area where the car wash is from the Walmart and these other stores, correct?
Correct.
In other words, there aren't any giant trees or walls blocking the view from there, right?
No.
And across the street, there's a Goodwill store. You see that there?
Yes.
Was that there in 2019 as well?
Goodwill, I believe so, yes.
And do you know whether they also have cameras, either Walmart or Goodwill?
No.
You have your cameras, right?
That's correct.
Okay. Now, I know that the state did not play the rest of the exterior, so I just want to play the video, if I may, to the end. They stopped it before the end. And I do realize I have to change that up there. Oh, no, it automatically changed. So they stopped it right about around 9:21. Is that about when they turned it off? Yes, sir.
Yes, sir.
Okay, so I'm gonna just play this to the end. So these are what we're watching now, are your employees doing their task, correct?
Correct.
And they've opened the doors, right?
Yes, sir.
They wipe the outside, the exterior of the vehicle, correct?
Correct.
And that's to get off any extra water and maybe a little extra dirt that didn't come off from the wash itself, right?
Correct.
At any point, though, they don't climb into the bed of a pickup truck, though, here, do they?
No, they don't.
That's not part of their job,
No,
right?
they're not.
Okay. And when they complete this task right here,
Correct.
the vehicle then drives forward, correct?
Correct.
Who does the driving forward?
It could be a driver or a manager on duty.
But it's an employee
Yes.
of Russell Speeder that
Correct.
does that, correct?
Yes. Correct.
So they're still doing the interior of the vehicle at this point, right? If you look
Yes,
at the. Am I right?
Yes, sir.
And the exterior, they're wiping around the edge of it, right?
Correct.
But they don't even lower the tailgate on the,
No,
on
we don't.
the, let me just finish my question. I'm trying to think of the right word. They don't lower the tailgate of the flatbed of the pickup truck, right?
Correct. Correct, yeah. They don't.
And I see there's a black car driving out. That car just was in the express lane and it goes out as well, right? And
I'm
that's,
going to object at this point, Your Honor, just narrating the video.
yes, correct. Isn't that a vehicle
Well,
just
there's an
going?
objection.
I'm sorry, Your Honor.
There's an objection, and the objection is you're simply narrating the video. Well, the court does not know if this line of cross-examination is leading to something other than just narration. So the court will overrule the objection, but counsel can make the objection if it continues.
I'm sorry.
Overruled.
Oh, okay. So there was a car that just pulled out behind the red truck, correct?
That one right next to him?
Well, the one before I stopped the
Oh,
video.
yes.
And so the purpose is to show that what we see in the behind here is that's the Walmart we see behind there to the right, correct? Behind where the truck is out into the parking lot, right?
That's correct.
And it's all part of that same parking lot there, right?
Correct.
Now at 5:10 on the thing, or at 2100, the truck is now moving forward, correct?
Correct.
And that was an employee moving it, right?
That's correct.
Okay.
Correct.
Hopefully it'll automatically go back to the, so I wanted to just ask you a couple more questions about Exhibit 138. Now, you testified that the employee is the one that fills this out, correct?
Correct.
And the time that's put in is the time the vehicle would have been brought up to the counter, that is that the occupant or the driver would be up at the counter in order to put in a request for some kind of detail, right?
Correct.
So the vehicle above, you were asked about this vehicle at 9:14, but this would have been a vehicle that came in at 8:44 in the morning, correct?
Correct.
And you indicated that a ×2 is different than a full detail?
Correct.
What is included? I'm not sure I quite understood. If an X2 is written down, exactly what does that mean?
It means the customer requests two individual service.
One was, you said, the carpeting.
Could be the carpeting, shampoo seats, or dashboard and console cleaning.
But you don't know which ones that was from this?
I don't, but the customer received when pull up into the driveway, talk to a associate who have a little sheet with all the services. So the customer pick up whatever service want and bring it back to the cashier.
But I'm asking you though, from this detail, this form that's been introduced, we can't tell what 2 services were requested, correct?
No, I don't.
Okay.
It's based on that.
All right, and then when it says needs to pay, for much of the people on here, except for Dylan down here at the bottom, which also says needs to pay, there's a price actually listed, correct?
Correct.
Was there a reason, just by looking at this log, can you tell why it wasn't a specific number that was written in versus needs to pay?
Just the cashier, instead of put the price, because the price means that the customer paid the amount
Upfront.
upfront, correct?
All right, and if it's not upfront, then you put down, or you're required, when I say you, I mean the employee is required to put down, they haven't paid yet.
Correct.
Okay. And that would be done before the car could be
Correct.
picked up, right?
Correct.
Okay. I just have a moment?
Yes.
Incidentally, without showing you that, well, actually, I'm going to show you that. The other video that you were shown you recall seeing this video. You indicated this would be at some time
Yes,
around
just trying to find
2:20,
references. How good are
between
you?
2:26 and 2:28 in the afternoon, right?
Correct.
And I'm just going to call your attention to the individual who just walked through the door.
We wash your car. We even testify for you in court. Yes, I think. Come. We give premium car wash.
And incidentally, when I asked you about the chairs, these are those chairs where a person, if they wanted to, could sit and wait for their vehicle to be cleaned and or detailed, right?
Correct.
And this is the woman who, behind the cashier. She worked at the time for Russell Speeder, correct?
Correct.
Do you still work there?
No.
And it looks like the individual, I see your employee counting something. Was that indicative of the fact that this person paid in cash?
That's correct.
All right. And what is your employee doing now? Going through her cash register and giving change?
That's correct.
Okay.
And the receipt.
And receipt.
And also indicate the car is in the back.
Okay. And then the individual leaves, correct?
That's correct, yes.
All right. The videos that we just saw, did you provide them to the investigators, or did they come and take what they wanted?
I provide access for the video system.
And they took what they wanted from it?
Correct.
So I just want to be clear, showing you again what has been marked as Exhibit 138, the log sheet. They didn't ask you for information about a Toyota Sienna that came in at 8:44, did they?
Don't remember.
And you haven't seen any videos from that?
No.
Okay. I just have a moment, Your Honor.
Yes.
I have nothing further. Thank you, sir.
Thank you.
No, sir.
Yes, sir, you may step down. Thank you. Attorney Manning, do we have witnesses for 2 o'clock?
We do, Your Honor.
And how many witnesses does the state have for this afternoon?
2, Your Honor.
Thank you. Does the court have to review any case law before we start at 2 o'clock?
Yes, Your Honor. I have one case to provide for the court.
So what we will do, ladies and gentlemen, is just,
Well-
well, first, the court should ask, do you expect, not counting cross-examination, how long do you expect your witnesses to testify on direct?
See, that's not pointless. This was to show the cars were getting cleaned and the cars involved in the murder were getting cleaned up and taken, like, so they couldn't be detected. Like, they were trying to cover up their tracks. You know, Fotis killing Jennifer, and then in the process, like I said, at some point Michelle pops into this, and I think that's eventually what happens here, but we're still waiting for that part. So it's not like it's completely made up yet.
Brief, Your Honor.
So we'll
For both.
resume, ladies and gentlemen, at 2:15. We'll take our lunch and recess until then. Please do not discuss the case.
Now, okay, guys. So this is a quick question. It is 10:53. It's 7 minutes to 11. The next part of this day, so it would be today, was an hour and 15 minutes long, which means if we watch it at 1.25, it's only an hour long. I'm fine with watching it if you guys are. We'll be done by midnight. And remember, there's going to be a break in the middle of this too at some point. So we'll chug on and we'll knock this out tonight and get caught up. All right. So that's my plan. How does the truck getting cleaned by a service implicate Michelle? I don't know if Michelle suggested this or they said something to happen. I don't fully know yet. Like I said, remember, part of a trial is you're telling the story. And part of this story is Michelle was involved as a critical piece of the conspiracy to commit the murder. So I don't know what she says, but it happens. You know, that they're claiming it, so we'll see in a minute what the fuck's going on. But yeah, as of right now, we don't have enough. Apparently, Alpha Fox says the last 30 minutes is worth it. Okay, so we get some good stuff out of it. So let's do it. Let's do it. Let's be honest. Here we go. Here we go. Yo.
We can.
I also turned it down a little bit just because Sheverhorn's voice is so loud in their fucking playback stuff. We're going to turn this down to normal for a second. Now we'll run back up to 1.2 and make sure it takes hold.
Please be seated.
Here we go. Here we go.
We'll wait for it.
We can continue, Your Honor. He's bringing some stuff up.
Thank you. Who is the next witness, please? Thank you.
The next witness would be Todd Holson, Your Honor, and then Dr. Gill.
We should probably take up the motion of limine first, rather than have a witness come in, excuse the jury, have argument. So the court has had the opportunity to read the motion of limine. Counsel, you may be heard.
Thank you. I don't know if Your Honor had a chance to read both the Rios and the Acosta case, as 8 Con App, which I cite, but there are some practical matters that I first want to address, and that is, this report was written in December of 2023. It could have been written and said the same thing 4 or 5 years ago, but the fact of the matter is it was provided to me at the end of December, right before New Year's, and it was not even previously presented in a draft form. I tried after that date, as did Attorney Felsen, to reach out to see if we could find any expert anywhere in the country
Baker.
who could testify that a medical examiner
Good morning.
cannot and could not testify based on reading an arrest warrant and looking at other court documents and rendering an opinion without having actually examined either body or parts of a body. I emphasize that because there are a couple where there was a femur or another portion of an individual's anatomy that a person couldn't live without or could not easily survive without. Previous to now, the only thing that that Dr. Gill had said regarding anything was in his warrant, was in the warrant from January of 2020. And in there, he had some private conversations with the police that are not documented anywhere. And he looked at some pictures of the, I think the bra and the shirt, and said at that time, a person would not be able to survive for long based on the amount of blood. That was the only thing he said. And if that's all he was going to testify to, you know, for 4 years, I assumed either it was inadmissible or I could cross-examine if that was all he was going to say. Now he's going to say, I read the arrest warrant and I looked at the probate findings down in New Canaan. And if Your Honor will note, I attached to my motion the probate findings of the Farmington probate judge who rejected almost the same evidence that was used in an ex parte proceeding that no one other than the family and the lawyers for the Farber family knew about. That happened just a couple of months ago in New Canaan. So we start with the fact that, and I wanted to quote it specifically from Barrios, because that's the case that Ms. Manning, as I understand, provided. Well, she didn't give me a copy, but I'm assuming Barrios was the case. I just asked that Ms. Manning indicate that that is the case she gave to the court.
Yes, 187 Connecticut Appellate 661, a 2019
Right.
case.
Right. So, and I just took some notes specifically with regard to the Barrios case. So, interestingly enough, the defendant in that case made the same argument that an expert cannot testify under 7-3 of the Code of Evidence to the ultimate fact unless under subsection B, where he or she can give an opinion that embraces an ultimate issue where the trier of fact needs expert assistance in deciding the issue. The court then goes on to say that that the defense argument there was because her testimony was not based on her medical knowledge and training, but on information obtained from police investigation, her testimony regarding the manner of death did not provide the jury with expert assistance with respect to that issue. Thus, the defendant argued in the Barrios case that the general rule regarding the inadmissibility of testimony that embraced the ultimate issue applied, and the testimony should not have been permitted. And the case, there was a couple of cases from out of state that were cited. The only one I'm going to refer to is State versus Jamerson, which is 1998 New Jersey Supreme Court case that's in Barrios, found at 153 New Jersey 318, 1998 New Jersey Supreme Court. Now, what's interesting though, as I continue to read the Barrios cases, the court analyzed the Jamerson case, which I submitted very much like this case in terms of a doctor opining on the nature of the death caused in a certain way based on reviewing of reports or police investigation and whatnot. But what the Connecticut appellate court said in Barrios, and I'm going to find the exact quote, the facts and circumstances of the present case support a conclusion that Williams's determination of the manner of death was based on her medical knowledge and expertise and not solely or primarily on police reports. This doctor, whose name was Williams, conducted the autopsy of the victim. She documented the injuries suffered by the victim, including abrasions, and they go into some detail. I'm not going to put them all on the record. Abrasions to the head and over parts of the body, bruising in other places, a skull fracture, subarachnoid hemorrhaging, brain injury, numerous fractures of both the scapula, the neck, lumbar vertebrae, and the left femur, and then conducted with a neuropathologist about these very injuries, and whether or not, and reviewed the victim's medical records from the hospital before she died, or he died. Then there's the quote. It is clear, therefore, that Williams's ultimate conclusion as to the manner of death was not made solely or largely on the basis of police reports, but rather on the medical knowledge, training, and experience. These facts stand in contrast, stark contrast, to those set forth in the State versus Jamerson case.
Hey, Brandon, $4.99. Thank you. Also good to see all the Baker Guys, coming over. This man needs objection. Yes. Although he's making a fair point. Why is the medical examiner testifying about anything? We have no body. He can't say a word. You know, it's the idea of that much blood. Well, how much is that blood? It's a lot. Well, that doesn't tell anything. A lot is not a medical term. So I agree. Mike, okay. Better. Hold on. Hold on. Is that better? Okay. So thank you, everybody, showing up for Baker. Thank you for the chat, Brandon. But yes, it is nonsense. The medical examiner can say, "Oh, that much blood would have been fatal." How much is it? You don't know how much that is. You didn't do a volumetric thing. So, yeah, I agree. It's garbage, and he's right to contest it.
That was set forth. So what's key to Barrios is that doctor actually performed an autopsy and then reached certain conclusions on the manner of death from having done that. The cases I cite, Your Honor, are not only Jamerson, but I cite to Tyler out of Iowa, Sosnovitz out of Arizona, that's Sosnowicz out of Arizona, and the Vining case out of Maine. But more importantly, what I do, Your Honor, is this is also clearly based on I have a copy of the report by Dr. Gill. It's almost entirely based on testimonial hearsay. It's not based on medical records or even someone else's autopsy. Now, what's interesting is apparently the defendant in Barrios, the lawyer, did not argue, maybe because it wasn't preserved, that this was actually, that it would be a Sixth Amendment violation to have an expert testify to an opinion based on testimonial hearsay, such as an arrest warrant, which is what Dr. Gill says he relied on, looking at some photographs. And the hearing in probate court also was in New Canaan, was also clearly testimonial in nature. It was also one-sided. As an aside, I was at the hearing in Farmington, which was the subject of Judge Evelyn Daly's ruling to not allow a finding because of the nature of the evidence. She needed more. And I remember at that time, it was one of the Farber attorneys. It was either attorney Dranginis, who was there, or attorney Weinstein, who represented the father's corporation or something. They were both there. And one of them, and I can't remember which one, said on the record, you know, even if the probate court were to make a finding that that Jennifer Dulos was in fact deceased and met and died prior to Dulos, because this was actually Dulos's probate hearing. I was there because all of my client's property was still in the house, and the house was now in probate. Everything that belonged to her and her daughter were still in there. So that's why I was even present in that hearing at that time. But they said, well, this would never be admissible in another case. It's blatant hearsay. It would be not admissible to prove anything in any other case. And I remember, I don't know if I said it or thought it at the time, I said, somebody's going to come up with some theory on how they're going to get this in. And I was waiting to see if that was going to happen. And lo and behold, they hold a hearing, and there's no media coverage of it. So I didn't know about it in October of this past year, where only the mother testified, Mrs. Farber testified, and one of Ms. Dulos's friends.
Is this better? Can you guys hear me now? Is it not choppy anymore?
They get the New Canaan probate judge on the basis of this one-sided hearing to conclude that she is deceased and was the subject of, I forget the exact language of that decree by the probate judge. I have to find that. I didn't bring that up. But what's also clear is there's a whole line of, so we have three issues. Right? One is the timing of this. They waited until New Year's. So we could not find an expert just to debunk this theory that a doctor of any sort could look at an arrest warrant, could look at a decree from a ex-party hearing in a probate court and look at a couple of documents and conclude not only that Ms. Dulos is deceased, because we're not contesting that in this case, but saying that, but that she was the victim of a homicide, that there's no other possibility just based on that conclusion. Now, that's based on nothing other than what's been not only presented in the court, but there's nothing other than in a police sworn, in an arrest warrant affidavit, and in a decree from a probate court, again, all testimonial. So I would submit that and I keep moving around here, so I want to stick to my points in order. So the timing prevented us from getting any kind of an expert to debunk it, number one, that no doctor should be allowed to do that. In fact, to my knowledge, I couldn't find any case since the Sixth Amendment.
How about now? Is it working any better, guys? I don't know what is wrong with it when it does this. So He's also right. No medical doctor can make these kind of opinions or shouldn't be allowed to.
Was adopted by, under the 14th Amendment in the 1960s under Pointer versus Texas, that would allow at least no appellate decision that of any repute. Could I find any decision that said that you could bring in a medical examiner saying, yeah, I read the arrest warrant, you know, we can just conclude she was a victim of a homicide. The jury can reach that conclusion based on.
Also, I wanted to say we got another super chat from Brandon for $4.99 saying, this guy sounds like he's going to cry all day, which ruins his arguments. Yeah, but he's making really good fucking arguments. I agree. He sounds very, given his pitch and tenor of his voice, but hey, that's, you got to work with what you got. Maybe you should smoke some cigarettes, get a deeper voice.
If there's sufficient evidence, but having the imprimatur of the medical examiner saying that in addition is quite frankly astonishing. But we then get to the fact that it's not just that this doctor would have looked at maybe the work of another doctor. Here, it's based solely on police speculation. I have raised, for example, as Your Honor knows, that in these warrants that were prepared by Detective Kimball, there are many falsehoods. The court did not allow the revisiting of that, but relied on the fact that Judge, and I disagreed that it was the law of the case, but the court made a finding that the court was bound under the law of the case to Judge White's finding, even though I submitted that even Judge White conceded there were errors in the warrant, but he said it didn't affect the finding of probable cause. But you have the line of cases that starts with Crawford, goes to Bullcoming versus New Mexico, and Melendez-Diaz versus Massachusetts in the 2011, 2009, that expand Crawford, so you can't even allow an expert to testify to what another expert did. That violates the Sixth Amendment, ironically. So here we're taking it one step further. It's not only based on not what another expert did, which would have been invalid under the Sixth Amendment, but we're taking not scientific stuff, just stuff that this doctor read from the police warrant and police reports, looking at some pictures, did no medical exam of his own, none whatsoever. In the Apostle case, it was the same thing. In Apostle, a Connecticut doctor opined that it was a sexual assault case, but opined that the sexual activity was forced, that it was against the will of the victim there, based solely on what the victim said, not based on a review of medical evidence. So that was in Apostle, they reversed the conviction and specifically said it was improper to allow a doctor to opine based on that. What's also concerning to myself and should concern the court as well is this is not a matter that I can cross-examine on, because if this witness is going to say, I relied on the arrest warrant, then chances are he's going to want to go into things he found compelling in the arrest warrant. If he does that, well, then we're getting to the point, which is one of the things that I'm concerned about, that is instead, it's one of these cases, I think it's one of the out-of-state cases, talks about it's not then the doctor's opinion about any factual basis, but his opinion on the thoroughness or the accuracy or the acumen of the detective who applied for the arrest warrant. And also the opining on the findings of the probate judge. And again, it was not something that was disclosed. I was not even aware of it until New Year's, week of New Year's after Christmas and before the trial started, that we even were aware that it had happened and that there was any kind of decree issue. So it violates not only 7-3 and 4, but it also is irrelevant. It's also prejudicial, clearly prejudicial, and it has no probative value. It's essentially taking away from the jury a finding that they would have to make based on inference after inference after inference. And I know at this point that the court has allowed in many things that I objected to, that at least I argued should not even have been admitted. So the court actually is, the jury rather, is in possession of more information than I submit should have been allowed. One of the things, for example, Dr. Gill is going to talk about is all the blood, et cetera, et cetera. Well, the court allowed in the luminol and the KM for a certain purpose, but Dr. Gill thinks that this is all blood and that it was confirmed as blood. And again, so he's relying on not only erroneous information, but again, the only way to even cross-examine him is to get into the fact that he's relying on information that's misleading and does not lead to the appropriate conclusion. And that we shouldn't even get to that point. Having a doctor, the medical examiner of the state of Connecticut come say, I'm going to rubber stamp what the state police did in their warrant and what a probate judge did in New Canaan is essentially taking away the right, not only of the defendant to have the jury decide the case, allowing a witness basically on lay testimony, because it's not involving any of his expertise as a doctor to make these conclusions. It's based solely, as opposed to Barrios, where that doctor actually performs an autopsy, to give an opinion on the ultimate issue. And without the opportunity to even cross-examine on that underlying issue, because that's going to bring in whether or not a judge signed a warrant, what the judge signed for, and how many lies there were in that warrant by Detective Kimball. So based on all of that and the cases that I cited, I submit that the court should preclude it. And then there's my caveat. If the court is even inclined to allow it, I submit, and I've asked for a Porter hearing. I've asked for a Porter hearing because there's no case, there's no article I can find where a doctor has been allowed to testify in a contested case.
We need not get that far yet.
Okay, but all right, but I just want the court to be aware that, this would be the first time that I can find anywhere, and I've tried to look up articles about it. There was questions about identifying people from DNA and whatnot. That's not in dispute, but using it in a contested case and arguing as a medical examiner in a criminal or even a civil case to prove something, there's no peer review articles on that issue that I can find.
Thank you, Your Honor. I just want to start by discussing the timing issue. Counsel did bring up the fact that this was in the arrest warrant. The arrest warrant was signed in January of 2020. There's a whole paragraph that is devoted to Dr. Gill and his statements, including what he reviewed, which is all similar to what he reviewed now, absent the probate report that just came out this past fall. In that paragraph, it indicates that he had made an opinion and that he was prepared to indicate that Jennifer Dulos had sustained an injury or multiple injuries that he would consider non-survivable without medical intervention. He characterized it as a event of homicide of violence to likely include some combination of traumatic blunt force injuries, such as bludgeoning, beating, and or sharp force injuries, such as stabbing and slashing. That's only part of his opinion that was in the arrest warrant. Your Honor, I indicated when I submitted the witness list, his name was on it, as well as the fact that what he would be testifying to. I did ask for him to document it in a report under State versus Manusis, as well as to clarify exactly what he would be testifying to for counsel's edification. That is why a report was written. Otherwise, we would just be going off what was in the arrest warrant, Your Honor. They have had ample notice that the state's position on Jennifer Dulos's death has been, since the beginning, a homicide of violence. That has been for 4 years now. So the idea to stand here and say that we don't know how to combat this, they've had 4 years to do so. With the argument that the opinion of the chief medical examiner in the state of Connecticut, who is an expert in forensic pathology, his determination of whether or not she is deceased and the manner and cause of that death is irrelevant and immaterial, which is counsel's words, in a conspiracy to commit murder case, I don't even think needs to be addressed at how ridiculous that sounds. It is very relevant, it is very material as to whether or not Jennifer Dulos is deceased. That is a factor that the state is submitting, is put before the jury. They can take what weight they want of it. Counsel, he is subject to cross-examination. Counsel can certainly effectively cross any issues that he wishes to do so. I would also refer to Section 7-4 on opinion testimony by expert witnesses. They can clearly base their opinions on evidence that is not admissible. I refer, Your Honor, to Section B. The facts themselves need not be admissible in any way, shape, or form, as long as if they are using it for the limited purposes of basing their opinion on, which is what Dr. Gill will be testifying to. Now, going forward on the Barrios case, I actually see the quote that counsel indicated as saying almost the exact opposite, saying that the forensic pathologist in that case can make a determination based on the medical knowledge and expertise and not solely and primarily based on police reports. Dr. Gill is not basing his opinion based solely on police reports. If that were the case, then we can call anybody off the street, say, read this report and tell me what you think. That's not what's happening. We are taking somebody with skill, experience, education, and years of testifying to forensic pathology and asking him based on that knowledge and experience, as well as a variety of items that he's looking for, not just, by the way, police reports, lab reports, photographs where he can make his own determination and come to an opinion that he is entitled to make under 7-4. I also believe that Barrios provides him with that. The concept that you can do the entire I guess, death consideration, I'll call it, for a forensic pathologist, and make a judgment call at the end of your consideration and not consider law enforcement is belied by Barrios and statute. It's just what they do. The idea that you cannot make that call because somebody is good at hiding a body is belied by anything that is out there. Just because a body has not been found does not mean that a medical examiner cannot make a determination. I don't think that makes sense in any way, shape, or form. Counsel cites the Apostle case. I actually read that completely different as well, because that court indicated the determination of whether or not a sexual assault was consensual or non-consensual is something that it's not outside the ken of a regular juror. And that is why the expert testimony was excluded, because it was something that was not that expert's opinion for what they were offered for, which is a doctor on his medical experience and knowledge. Dr. Gill is an expert in forensic pathology. He is here to offer his opinion based on his review of numerous factors and numerous police reports. Counsel has all that. Counsel has been aware of that since 2020. And I think it is entirely relevant and material to our case and the case against Ms. Troconis. So I would ask the court to deny his motion.
Well, the court
Could I
has
respond
heard,
briefly?
the court has heard what it needs to hear in order for it to determine whether it will grant or deny the motion in limine. Both counsel referred the court to State versus Barrios, 187 Connecticut.
All right, before we get to the judge dropping his bomb here, KJ for 19.99. Thank you so much for the support. I appreciate it. Saying money for homemade claw. I appreciate it. I mean, technically it's like a vodka seltzer, but hey, they're good. I like them. So now I just need to start drinking Doers and seltzer like my grandpa. So here we go. Thank you very much for that. I appreciate it. But let's see what the judge says. And yeah, I do agree with Alpha Fox here. It's like, put your name on it. Proclaim it a homicide, cite a cause of death. J-Bet, well, the medical examiner is trying to say these clothes are soaked in blood. The amount of blood it would take to soak your clothes would put you in medical danger because it takes a certain amount of blood to get all over your clothes. You need, so many liters of blood in your body. Losing a couple of liters can be fatal. But that's the thing. Like, there's no volume content. Like, how do you know it's all blood? Like, some of it might be blood. Some of it's not. Like, but a jury's going to look at those clothes like that bra, just pure red. They know that's blood. We all know it's blood. So that's where we're kind of running into the issue here.
Appellate 661, a 2019 case. The court is reading from section 2 of that opinion. In that case, Susan Williams, a pathologist in the office of the chief medical examiner, who had performed the August 11th, 2014 autopsy of the victim, indicated initially that after that autopsy, further investigation was necessary.
No, Lofi, I haven't tried that. I'll try it now.
Circumstances pending further investigation was the conclusion. On December 24th, 2014, she amended the manner of death to homicide.
We're covering that on Thursday.
The court is looking at the facts in Barrios and the facts in this case. In Barrios, there was an autopsy. The first autopsy yielded the conclusion, circumstances pending further investigation. Now, at that time, the state medical examiner's office had to classify the manner of death as one of the following: unable to determine accidental, suicide, natural, or homicide. As of August 11th, unable to determine would have been the conclusion. So the question then becomes, well, what changed between August 11th and December 24th? Law enforcement reports. The jury in this case has more evidence to consider than Dr. Gill. The code states that concerning an ultimate issue, opinion by an expert, an opinion by an expert on the ultimate issue is admissible essentially if that expert assistance is needed by the jury in deciding the case or deciding the issue. And the issue here is whether or not there was a homicide. It is clear to this court, based on the 4 weeks of evidence that the jury has heard, that the jury can come to its conclusion and it need not rely on expert testimony. Again, the jury has heard more than Dr. Gill could testify to. The motion's granted. And who was the next witness, please?
Todd Holson, Your Honor.
You can bring the jury in.
Could you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Please state your name and spell it for the record.
Todd, T-O-D-D, Holson, H-O-L-S-O-N.
Holson, you may be seated.
What happened there? The judge has said that the jury can make a conclusion that Jennifer was murdered without the expert testimony of the medical examiner, and that's true. The jury can use their common sense and experience to look at all those blood-soaked clothes. Looks like they've got stab wounds cut through the shirt. Looks like there's puncture wounds through it. And a reasonable jury can conclude, wow, it looks like Michelle got worked over and died. They could take a look at all the stuff that was in those bags, how everything hit on luminol. And they can determine, well, it wasn't all rust or it wasn't all radishes. It was likely all blood. The fact her bra was all bloody. The fact there's big old blood smears, it looks like, in the garage. The garbage can's full of luminol hits for suspected blood. They found suspected blood all over the place. They found it all over the inside of that truck. But they couldn't get any samples out of it. So the jury can come to the conclusion on its own that Michelle got killed and chopped up. They don't need the medical examiner to say it, so it's a fact that they can independently come to. They don't need his testimony to come to that conclusion. So that's why he said that. He didn't really rule in favor of the defense because the guy's still coming in to testify. So Hashu, you haven't really missed a ton. No, this has been a very, very dry trial.
Your Honor, if I may just approach the clerk and mark a few items, I would also stipulate for the record the presence of the jury. If I may just have a moment.
I stipulate the presence of the jury. So.
Thank you.
Good afternoon, sir. How are you?
Fine, thank you.
Mr. Wilson, do you own 386 Wheat Street?
Yes, I do.
Okay, if you can just explain to the jury, please, what kind of property is it?
Sure. The property is a residential property. It's known as Weed Farm. It's on about 32 acres. And
Weed Farm.
it consists of two different properties, but it's known as 386 Wheat Street. There's a fence around the entire property and two gates at the two entrances off of Wheat Street.
Sir, how close are you to Waveney Park?
I would say about a mile.
Is that north or south? Where, in what direction?
I would say it's south.
Do you have any video surveillance on the property?
We do.
Did you have video surveillance in 2019?
Yes, we do.
Could you please just describe a little bit about the video surveillance, particularly the surveillance you
Garrett pays us for $20. I would like to purchase one shower text, sir. You know, I should do that. I should have like, it's like those chicks on OnlyFans. You can have the list. You can have the, I could do like the Nick Rekieta experience. You know, for the first tier, I'll send you a shower text and I might yell at you over the phone. The second one, I'll berate you on a live stream. I should totally have a menu like that.
had that covers the road in 2019?
Sure. The camera system is a server-based system that resides in our house. The software program is known as DW Spectrum, and it time syncs with the internet. There's a total of 75 cameras on the property, 5 of which are close or facing toward Weed Street.
So the time of the 5 that are facing Weed Street, is the time accurate?
Yes, it is.
May I have one moment, Your Honor?
Yes.
That's fine. That's fine. If I can, just for the record, Your Honor, the TV screen behind the witness displayed to the jury is off. The state's going to show 139 at this point and inquire of the witness, if I may, Your Honor.
Yes.
Sir, is that TV on in front of you?
It is not.
And oh shit, damn it! I clicked on the wrong thing there. Yes, the testimony got excluded, so that's why we're a lot shorter today on the. That's why we're a lot shorter on what's happening today, because the testimony got excluded. So the medical examiner's out. He can't comment on the cause of death, but he could say, yeah, that's a lot of blood. But yes, to have him come in and say a cause of death, that would be really impossible. But there is a way for the jury to come to a conclusion, so they don't need his testimony. Like I said, jury could look at everything and determine whether or not somebody's died. So I don't know if I didn't make that clear. My apology. But yes, that he is out, which it's kind of a win, but it's not like that's not a home run. It helps a lot, but remember the jury's going to say, like, we already looked at this and she's fucking dead. Like, what are you doing? Don't play us, Holmes. So the jury's going to say, don't bullshit us. And Sheverhorn's going to have a tough time trying to say, yeah, we're not bullshitting you. Like I said, my bad on that. We're fixing that. All right, here we go.
Actually, going to show you what's been marked as file 1.
We don't skip people.
You can actually take a look at that screen in front of you.
We do the
sir.
whole
Do
thing.
you recognize what's depicted on that screen?
Right now, it says no signal.
Wow. All right, hold on.
That's the $100 tier, Eric.
Okay.
Okay. Do you see it now?
Yes, I do.
Okay. Do you recognize what's depicted on that screen?
I do.
What is depicted on that screen?
This is a camera that is on the north side of our carriage house facing toward Wheat Street.
And I'm going to press play and have you watch the video if I can. Oh, there we go. Now, sir, the file I showed you has been marked as a video feed 1. Is that a from time 7:31:50 to 7:32:06. Did that fair and accurately represent what came out of video camera 1 on your property on May 24th, 2019?
Yes,
And by the way, did the police come to see you in 2019?
yes, they did.
Did they ask for review of your video surveillance system?
They did.
What did they ask for?
They asked for a block of time between 7 a.m. and 12 p.m. on May 24th.
Did you provide them with the video cameras for that time period?
Yes, I did.
And is this one of the camera time frames that you provided to the police?
Yes.
Okay, State would offer file 1, Your Honor.
I just have a couple of questions to clarify, if I may. Sir, in just looking at the same thing you just looked at, it looks like it's stop action. Was this, when it was given to the police, was it a full, like, I forget the word I'm looking for here. Was it a stop action, or was it an actual video that flowed?
It was an actual video. It's continuous feed.
And so what we're seeing, you agree with some kind of stop action, sort of like in a bank where they do it every 5 seconds or 10 seconds?
It captures at 30 frames per second, but I'm not sure. I'd have to see it again, but
Because wasn't what we just saw not an actual continuous feed, but stop action? So isn't that what we just saw?
Objection, Your Honor.
Well, again, this is voir dire. It's the integrity of the offer. So if the integrity of the offer goes to whether it's continuous or stop action, the court is going to allow it.
so it is, what was the question again, please?
Yes, what we just saw, that wasn't a continuous feed. It looked like it was a stop at, you see a car and then you don't see the car, it disappears. Wouldn't that make this stop action that we just saw?
I really can't answer that. It is continuous feed.
What you have is continuous feed, but what we just saw was not, correct?
Could I see the video again?
Could I ask that it be shown to the witness again,
Yes.
please?
Perhaps it is a little choppy based on what I'm seeing.
So it's choppy. That's not how you know your system operates, correct?
That is the way the system operates. It's
What you just looked at is, are you saying it freezes and then shows something after, or is it like a video? It should show a smooth.
well, my particular system has 75, or at the time had 75 cameras on it, and it's a server-based system. So perhaps there's a little choppiness for that reason.
Well,
75 cameras, damn.
The threshold question would be, in this court's view, do you regularly view video of events that have occurred?
And that's correct. Do you regularly view this? Do you regularly view events like through your camera and your DVR? Yes or no? Yes. Does it normally look like this? Like, does it get choppy? Well, if he says yes, okay, well, you're stuck with that. If he says no, do you know why it's not playing correctly? And then that becomes an issue of whether this voir dire, you're voir diring this evidence, and whether or not it's reliable. So
Earlier in the day or in the past?
Yes, I do regularly view events during the day and also the history.
Now, in that review or in those reviews, do you see stop action video?
what kind of fuck? He's like, I normally review my cameras. But yes, now the judge is getting to this. Does it normally play like this for you?
Running, or do you see continuous video running?
I see continuous video running.
then I object.
Your Honor, the state would offer it. This is a 16-second clip out of that day, the way that it was played, he indicated it's a fair and accurate representation of what he saw. Whether it plays choppy or not, there's no indication. I can inquire whether or not there's any indication that has been tampered with or changed, but the state would offer it as a fair and accurate representation of that 16-second time frame.
Well, then there has to be an additional question.
No, that's you can't claim, oh, it shouldn't look like this. This is what it looks like, and the guy's saying this is not accurate. That's not a fair and accurate representation of your camera feed normally. So there's now a massive issue of whether or not this is reliable and can be presented to the jury. I don't know what he's going to ask next, actually. I'm kind of actually a little stumped because there's do you know why? Maybe that's the question that gets asked, but no, this is garbage now. If he's like, no, this is not what it should look like, you've got a big problem with your evidence, prosecutor.
Sir, did you view any of that video that you just saw either prior to the police requesting it or afterward?
I did not view either before or after.
Your Honor, if I
Well,
can.
the court hasn't concluded.
I apologize, Your Honor.
Because the witness has said he didn't review that particular video before or after, he is not able to indicate whether at the time he could have viewed it, there was stop action. If he testified that when he viewed it, it was continuous, but today it's stop action, then there would be a question of the integrity. But that's not what the witness can testify to. So the court will allow it.
Ooh,
Objection
yeah,
to those.
well,
Sir, I'm going to
hold on.
take a look at
Yeah,
your screen,
wait,
please. I'm going to
well,
show you what's been marked as filed.
So we don't know if that's how it came. We don't know if how it got produced. And since he can't say he doesn't know, is it still reliable? Is there issues with the integrity of the chain of custody of it? No. Schemelhorn should still object, and maybe Schemelhorn's going to fuck with them and say, normally when you watch it, is it stop motion? But yeah, did he watch this particular one before? Yeah, I get where he's going. I get where he's going with this. I disagree with it, but I understand what he's doing.
2 marked 7:31:30 to 7:31:46. Do you see the screen, sir?
Yes,
Thank you. Do you recognize the camera angle?
yes, I do.
Where is that camera angle from?
That camera is facing Weed Street, and it's at the service or south entrance of our property.
And this video feed is actually 31 minutes long, sir, if you could just keep watching a little bit. Does that fair and accurately represent what your camera angle looked like in 2019?
Yes,
And this encompassed the time period that you gave to the police?
yes,
And the state would offer it, Your Honor.
If I may,
Yes.
as you're watching this, you also notice this is stop action, correct?
I would say it's choppy.
Choppy, but when you've looked at your system, and let me ask you this, did you have the same system in 2019 that you have now?
Yes,
When you would watch any of your videos from these cameras, was a smooth, continuous video action that you were
He's
watching?
bringing it up now, Stabby.
as I see it today.
No, normally.
Well, normally, as I see it today, I've upgraded the system, so because we've added cameras during that period of time. So perhaps it's improved over time.
Okay. Well, I'm talking about if we go back to 2019, was your video from this angle, was it a continuous, smooth video, or was it stop action where a vehicle will appear and then disappear, and then another one will appear and then disappear?
It was it was a long time ago, back in 2019, so I can't really say.
So can you even say that this fairly and accurately represents the way your camera feed operated in May of 2019?
I would generally say yes, it is.
It is, so
Yes.
that it was a stop action camera that you had, right?
I'd
It was
object,
not-
Your Honor,
Well,
that's,
well, now it's not a matter of voir dire, it's a matter of cross-examination. So the witnesses testified that it's a continuous system.
And he's allowed to go into this on cross-examination. We're now into the voir dire. The basics of it are there. Okay, now he's allowed to dig, and he's digging hard, and he's digging good. Carrie, you bring up a good point here. As a video editor, these attorneys know nothing about video. Yes, but that's just like in the Jennifer Crumley case. Those people, even the prosecutors, they're not gun people. So they're talking about dumb shit like thrust per squeeze almost, basically. If this was a car case, most of them aren't going to know cars. This is not uncommon. This happens all the time. So, yeah. Yeah, but I think the judge is going to allow him to dig because now he's allowed to dig. Let's see.
He refers to the video progression as choppy. Counsel refers to it as stop action. The witness has not testified that he had a stop action system. The witness has also testified that when he reviews video, there does not appear to be, when he reviews video of past events, there does not appear to be what he refers to as a choppy progression of the video. So the court is going to overrule the objection.
sir, do you have a specific player on your camera video surveillance?
Yes, I do.
What's the player called?
It's called DW Spectrum.
And
And
is
it's
that specific to the, I think you said, how many, 90 cameras you have now?
currently 85
85.
cameras.
Is that is that specific to those 85 cameras?
It is.
Okay, and when the police inquired with you on your video surveillance, did they come in and download the video from you?
No, I downloaded it through the help of the company DW Spectrum.
Okay, and you actually downloaded it, did you then provide it to the police?
Yes, I provided a thumb drive.
Okay, and that was with the help with your company?
Yes, that is correct.
Okay. And I'm going to show you video feed 3, please. Sir, if you could take a look at the screen in front of you. And do you recognize what's depicted in that video?
Yes,
What area is that?
that is also the service entrance, the service or south side of the entrance to the property.
And does that fair and accurately represent what the video camera looked like in May of 2024 between the time period of 7:30, and 7:30,
Yes, it does.
Oh, 2019, thank you.
Again, I'm going to not ask the same questions again, but I thought, did you indicate, have you watched any of these videos before today?
Recently, I watched them just to familiarize myself with this, but
The particular ones that you're just looking at? now?
right, but I had not seen them prior.
When you watched them, were they choppy like this?
I would say they're the same as what I recently watched.
And you mean when you watched it this year, correct?
Yeah.
But I just want to be clear, but your system at the time was not a choppy video, correct?
The system at the time, I don't recall it being choppy or not choppy.
I'll just have the same objection.
Overruled.
So I'm going to have you take a look at video feed 13. Do you recognize what's depicted in that video?
Yes, I do.
What is it?
This video is attached to the south side of the carriage house and is facing south.
And sir, if you could watch the video. Does that fair and accurately represent what your camera feed looked like on May 24, 2019 between 7:31:30 and 7:31:45?
Yes,
State would offer that, Your Honor.
I have no objection to this one.
What's the number, please?
That file would be video feed 13, Your Honor. This is all out of states 139.
The state's 139 offered in its entirety?
I have, Your Honor, I have one more video feed. Council requested I go through each one. So if I may do that first.
Yes.
Video feed 18. Sir, if you could take a look, do you recognize what's depicted on this screen?
yes, I do.
What is depicted?
This is another camera on the north side of the carriage house, and it's facing north.
Does that picture fairly and accurately represent what your camera feed looked like on May 24, 2019, between 7:31:53 and 7:32:09?
Yes,
There are two maps on the file as well. I'll show you those now. First marked 386 Weed Street in New Canaan. Sir, do you recognize what's depicted in that map?
yes, I do.
Is your property depicted in that map?
Yes, it is.
State would offer that, as well as, if I may do the next one and do them both together. Sir, do you recognize what's depicted on that map?
Yes, I do.
This is titled 386 Weed Street map, Your Honor, on states 139. Do both the maps fairly and accurately portray your residence 386 Weed Street and the surrounding area?
Yes, it does.
Okay. State would offer the entirety of 139, Your Honor.
Other than my previous, I don't certainly object to the map, so I'll just reserve what I had previously argued about the videos, but
Thank you. State's 139 admitted as full.
Thank you, sir. If you wouldn't mind taking a look at the screen behind you. Sir, is 386 Weed Street depicted on that map?
Yes, it is.
Would you mind going up to the screen and just pointing to it?
This is the entrance to the property, goes all the way back and encompasses this area.
Is the entrance and exit to your property on Weed Street?
Yes, it is.
Is there any other way to get onto your property from any other street?
No, there's not.
Now, you moved your finger throughout the, I guess, entirety of the middle of the map, is that correct?
Yes, that's correct.
Is there a fence surrounding your property?
Yes, there is.
Okay. Sir, do you know where 69 Wells Lane is?
It's approximately over here.
Is there a way to get from your property to Wells Lane through the, I guess, the brush and the trees?
Not really. There's brush and trees. There's the fence, and then there's wetlands, some wetlands in between.
Okay. And the fence is the one surrounding your property?
Yes.
Okay, thank you. One more map, sir, if you can. And your property, if you wouldn't mind pointing it out, please. This is Weed Street and New Canaan map. And for the record, he's pointing to the, again, the middle bottom of the screen. Sir, what road does Weed Street interact with on the top?
Weed Street goes to Frogtown Road.
And does Frogtown Road interact with Wells Lane, or intersect with Wells Lane, I should say?
Yes, it does.
If you could just point that out. Thank you. Now, do you know where Waveney Park would be?
Waveney Park is off the screen to the bottom right.
Thank you, sir. Now I'm just going to play video feed 1. You can have a seat. Now, again, if you can explain to the jury what camera angle this is.
Sure, this is the camera on the north side of the carriage house, and it's pointing mostly east, but a little bit toward the north.
And that road going across, I guess, left to right, what would that be?
That would be Weed Street.
Oops, sorry. And I'm going to play video feed 2. Sir, if I can, I'm going to pause this. What area is this?
This is the A camera pointing toward Weed Street at the south entrance to our property.
So the camera we just saw, is that towards the right or towards the left out of this exit or entrance?
The previous camera's to the left or north. This camera's to the right or south.
Okay. And this is between 7:31:30 and 7:31:46. I'm gonna stop it there and play video feed 3, 7:31:30 and 7:31:145. So and do you recognize this area?
Yes, I do.
What area is this?
That's the same camera facing Weed Street, and that's the one to the south, or as I mentioned before, to the right.
And I'm going to play video feed 13, sir. Now, this 1, 2, 3, 13, 18, are those your camera numbers?
Yes, they are.
Okay. So
That's like one
what area
frame a
is this?
second. Jesus Christ. that's
This is a
awful.
video camera on the south side attached to the carriage house, and it's pointing south.
The roads on the right of the screen, you can see those. Are those to your property?
Yes, that's Weed Street.
Okay. Oh, that's right. You're facing Weed Street over here where my cursor is?
Yes,
Okay. And through the trees and brushes over here?
yeah, that would be Weed Street.
Okay. And one more camera, sir, video feed 18. What area is this?
That is a camera attached to the carriage house on the north, toward the north entrance, and on the right is Weed Street.
And this is 7:31:53 to 7:32:09. I'm going to play it. This is Weed Street up here.
That is correct.
Okay. I'm gonna stop it there. Sir, how many hours did you give the police department back in 2019?
From 7 a.m. till 12 p.m.
I'm going to show you, Market States 140. If you can just take a look at the screen in front of you. Actually gonna stop it there. Sir, do you recognize this area?
Yes, I do.
What camera angle is this?
That's the camera attached to the carriage house facing north. Weed Street is on our right, or on my right.
Is this the same camera angle that we just witnessed?
Yes, it is.
Go back a little bit. Okay. So is that between 10:30 and 10:30, well, 10:30:05 and 10:30:15 seconds?
Yes, it is.
Did that fairly and accurately represent what your camera angle depicted on May 24th, 2019?
Yes, it is.
Did you provide that to the police?
Yes, I did.
State would offer 140, Your Honor.
No objection.
140 admitted as full, the state's exhibit.
And briefly, sir, if I could just turn your attention to the screen and
Yeah, there have been some good things, like Jennifer has made comments that Fotis should have buried the bitch where the dead dog lives. And then she's caught on camera when other evidence is getting thrown away from the truck. So yes, she's got a lot of circumstantial evidence that does not look good for her. But that's so far it's only circumstantial. As far as what am I working on, I am deburring 3D printed materials, and that's all I can say here on YouTube. So, shh about that one. That's all I can say. It's a surprise tool that'll help us later. Well, we'll keep going here.
sir, did you indicate where Waveney Park is in relation to your residence?
Yes, I did.
And where was it?
It's approximately a mile away
Okay.
toward the south.
Thank you, sir. I have nothing further, Your Honor.
Thank you.
No questions.
Thank you, sir. Thank you. You may step down.
Thank you.
Ooh, he just let him go.
Thank you, Your Honor. I have nothing further at this time.
Thank you. Does the state have witnesses to call tomorrow morning beginning at 10?
I do, Your Honor.
Thank you. So ladies and gentlemen, that concludes today's session. Plan to resume tomorrow at 10 o'clock. Please do not discuss the case, and please do not follow any media about the case. Have a good evening.
All right, guys, that's it. So, Zap Brannigan saying, but look at it, a bamboo fast. Yeah, you know what? They are fast, but I have an Anycubic Cobra 2 Pro, and that was a Christmas present from Future Mrs. Martin 2.0. For what it does, man, it's good enough for me. I mean, it prints shit out fast. I like it. It's easy to run. I know how to run it. It's retard proof, so it's good in that regard. So I would recommend the Anycubic because I can run it. And if I can run it, you can run it. The slicer program that comes with it is actually really good. Like I said, I've been able to figure out how to do it. So it's not super hard. It's a very intuitive interface. So I would just recommend that. Yes. Okay. You have an X1C. Yes, I understand, Stabby. I'm just saying for what I've got, it works good for me. It's good enough. Just as good. That's what I'll say. So guys, yeah. So that's day 21 of Michelle Troconis. I know I thought we'd get a little more out of that mileage there, but I don't know why Attorney Schemmerhorn left a lot on the table there. Didn't really go after the guy. But I guess the judge is not buying his arguments, which I think is wrong. I don't think it's good. I don't think it's fair there. B. Jefferson had a question. I didn't see it. I'm sorry. So, if you could say your question again, I would appreciate it because I'll answer it. Let me see if I can find the question here real quick. I don't see what Jefferson said. B. Okay. I wonder how often lawyers go to play the video and something else pops up. Not normally. It's not normally a problem because you've got everything set up just for that. So the other stuff doesn't usually pop up. So whatever you're trying to set up there is generally ready to go. You're playing off of usually it's not stuff on the hard drive. It's usually thumb drives or CDs full of shit you're playing off of because remember, those CDs go back with the jury. So that's normally how this is done. Although, given the scope of all this, I bet they have that might be the jury laptop because the thing sounds beat to shit and it sounds like it's about to die. And that's usually the laptop the juries get to take in the back with themselves because the good laptops are reserved for the actual offices. So yeah, like I said, this is a kind of a boring trial. Like they're going through all the boring stuff, and they better have more than this if they're trying to convict Michelle. I don't think there's enough here at this point. A jury might say screw it, but I don't know if they can prove she knew what all that blood and shit was, and that she knew it was all blood. I think that they're reaching, and hopefully they got more because if they don't, she's walking and. If this is all they really have, it is a shame that they prosecuted her. But I also get it. Fotis Dulos committed suicide. So, the cheese stands alone. And, the government workers want that cheese. So, doesn't excuse it, but I understand. So. Yeah, boring trial is better than no trial. So the trial does have a lot of. It's had a lot of if you wanted to it's been very good about laying out chain of custody and laying out progression. So it is very helpful in that regard. So there has been a lot of that. So I would recommend it in this sense. And if you want to learn a lot about the DNA stuff and how they really go through it, the people involved have really been very, very good about laying out how all the processes and everything's worked. There's been a lot of good objections by the state. And by the defense, there's been a lot of good motion practice. So there are a lot of things here. And this judge, if every judge was like this judge, the world would be a better place. He's very good about explaining why he's doing what he does. Doesn't just say, because I said so. He generally tries to make an effort to make it known what he's doing. So, yeah, overall, it's not bad. Not bad at all. Yeah, there's no Vosh moments. No Vosh moments. Yeah, well, it's a pickup truck passing at rest stops, and this is the one where they threw all the shit in the garbage cans all over Hartford because they went out to the ghetto parts of the city and did it. So, yes, but this is where they were on the Connecticut highways. Carrie, if you hate this judge, you really hate other judges because this is far from the worst judge ever. I can tell you that much. So, there was another comment here. I didn't get the chance to do the super chat. Didn't have a good time for it. D for $20. Thank you, D. Is saying, you heard it here, chat. You can get the full Ricada experience. With enough grainy screen caps of tits and pretending to be a crush from high school, you too might get a picture of Sean Cheeks gripping his 3D printed Glock. I think I should come up with a menu, though. I'll post it on Locals. Donna Addison goes on trial next month. Yeah, I've heard. I need to get caught up on that because I don't have the full story on that whole thing. So, yeah, and she got caught trying to flee, so even funnier for her. How much money you get with a bottle in my ass cheeks? More than you have. I'll say it like that, Zaven. Also, toenail clippings. Class me back says, is there a downside to buying a suppressor? No. I mean, what's the downside? I mean, yeah, the government knows something, but they already know what you own for the most part. You know, they know all the credit card records, financial statements. You know, they know. They know. I mean, they know. So I don't think you're going to, it's not going to make it any better. Now, if you're doing an illegal one or a homemade one and you don't tell the feds about that, well, that's another topic for another day. But overall, no. If I mean, there's no, they already know. They already know what you have. Let's be real. They have all kinds of data collected about you, so this is not going to be the make or break. So, hate to doom pill you on that, but they do. They keep track of everything, credit card purchases, your browsing history, so they know what you already own. They know. So don't be afraid of them, because when you need it, it'll be worth every penny. They're also cool, because you get to go pew-pew. And what's not cool about that? So. Did I ever dig in on the Hawaii versus Second Amendment? I covered it last week with the spirit of aloha. We should have fucking deported all those Hawaiians, those dirt-worshipping savages. The spirit of aloha, bro. There's a reason why we took it over, Hawaii. Ohana means family. Oh, is that from Moana? Did I share my thoughts on the Russian space nukes? It's not Russian. The idea of there's no benefit to putting nukes up in an orbital space platform. The only reason why you'd want to have an orbital platform is for kinetic strikes, like rods from God. And the funny thing is, like, that shit predates Call of Duty by, like, the concept of rods from God is, like, 45, 50 years old. I mean, you go back to Robert Heinlein in The Moon is a Harsh Mistress. The people on the moon used the computer to help calculate what was necessary. And they made a large like a magnetic catapult ramp, basically like a big rail gun, and they chucked rocks at Earth as orbital bombardment tools. So it's more than likely some sort of thing, probably like the X-37, where we've been running that thing for 900 days in space in low Earth orbit. Like, what the fuck were we doing with that? We were doing some sneaky breaky shit, I bet. So I guarantee you it's something more like that. It's not necessarily space nukes. There's no real advantage to them. I really don't think so. And it's also just really kind of ridiculous how, like, as the Ukraine deal falls apart and all the funding's drying up, oh no, the heckin' Russians have space nukes or something. Bullshit they do. Bullshit they do. I'm just saying, I'm calling bullshit. So I'm not saying for you, I'm just saying in general, like, I don't see it. And if they do, then fine, then we build our own shit. Like, we've withdrawn from treaties, we withdrawn from this, we withdrawn from that. Why would you sit here and, like, us as a country to sit here and go, what do you mean you're doing stuff? And it's because we've told them to fuck off, so they're fucking off. Yeah. Wasn't it the plot of Space Cowboys? Well, that's because the satellite was crashing. But yes, the idea that they've got an orbital platform for launching. But I could see that happening back in the 60s or 70s when like missile technology wasn't the best. So you're like, I want an orbital platform where I could just start dropping nukes on people. But with, you know, the introduction of multiple independent reentry vehicles, so like, you know, you got multiple warheads and they all kick out and fly different directions. They can dodge anti-ballistic missile programs. Yeah, there's a lot of stuff like, you know, we have the ABM treaty and shit like that. Then we have the treaties about like modern, like de-weaponizing space. I just don't see, after a while, by like the 70s, that probably became a non-starter of an idea. So yeah, the concept of Space Cowboys of like the Russian having a sleeper platform up there doesn't make any sense. I mean, that wouldn't have been able to have any real use after a while. So I don't buy it. Like I said, this is all same people that told you this, you know, the intelligence estimates. Yes, they also said there were WMDs in Iraq. There weren't. That Hunter's laptop was fake. It wasn't. You know, oh, it's a disinformation campaign. According to who? The intelligence community. And they don't ever lie to us. You know, they didn't create Operation Northwoods. They didn't, you know, get to the Operation Operation, I was about to say Hummingbird, but Mockingbird, although we had a lot of Nazis working for us. So it's a combination of Hummingbird and Mockingbird. We like Operation Mockingbird. You know, all kinds of shit out there. So no, I don't trust the fucking intelligence agencies. So what about, Nico's asking, what about holes up in space? Like, why? Because they want like more women to get green cards? Like, yeah, fine. We'll eject them all into space. Let's put Kiev into space. So we don't have to worry about it anymore. Tilly's saying an EMP attack. Yeah, but that's already part of like any, like all nuclear strike packages have EMP strikes in them. So like, I'll say this much. Like, if you ever watched the day after that TV movie, they actually got that part right. Like, the first missile strike is a large scale EMP attack for a region, and then the nukes come raining in. So no, you've already got that set as part of your attack package. There's going to be the first nuke in as an EMP high above, and then the other ones come in right behind it. So you don't need a strike platform for that or an orbital platform for that. That doesn't make sense, because if you're on the wrong spot of the Earth, you're basically launching still anyway from the ground for the most part. I would argue in that sense, but I understand what you're saying. Also, nowadays, an EMP attack, it's not like what we thought it was going to be. I mean, like, yeah, there's so many other ways. Like a cyber attack is going to be more effective than an EMP attack, really, now. Bella's saying, I can tell you that NASA Redstone has been working and holding a lot more briefings. Oh, I bet they have. Because once you tell Russia to fuck off, I'm sure they're starting to weaponize space. The F-117 was flying for years before the mortals learned of it. Yep, that's true. Winter Soldier sets the plot of Gundam, yes. Where are you guys? Yeah, Stacy, like I said, how about an EMP? I mean, there are a million fucking ways you can do an EMP now that are instead worse. Cyber attack, you could take a little drone and fill it full of strips of tin foil and fly it over a power station and disable it. There's a million ways you can do it. Hashoff said, I'm making my point, Sean. Just took a bit to get there. Yeah, I'm sorry. I didn't mean to. I don't know. We're talking. Everybody's talking at me. We don't have nukes up there. We have satellites up there to shoot down those satellites. Yeah, we have hunter killer satellites up there. Totally, we do. So, Elm Park is an operation people like to forget about too. Yeah. Drone chaff is a real thing. Have I been keeping up with the 3D printed rocket launcher guys? I know they made the Fliegerfaust, but I haven't seen it shooting. Tell the lame squares in the chat to yes, please touch the like button. Touch it very affectionately. So, Big Happy says we shot down a satellite with an F-15 before. Yes, that is not the most effective way to do it, and that also creates an issue of a a cascading effect where we might litter low Earth orbit with space debris, and then things are unusable. That's a problem with destroying satellites like that. Using the hunter killers or blinding the satellites or disabling them, that makes it a little less dangerous because space full of trash is a dangerous idea. Eventually it becomes a like I said, the worst case scenario is it's I forget what the Kessler syndrome. Yeah, sorry, I was looking it up real quick. What is that called? Yeah, it's just there's too much shit in orbit. Well, that's why you got to be careful about blowing stuff up. So, China's test will leave debris for generations. Oh, yeah. Yeah, it will. But they've already tested one before, so. So, that was really it, guys. I mean, do you guys have any other questions? Like, if you want to talk about this stuff, we can hang out for a minute. But otherwise, I'm going to keep working on this, and I'll probably be hanging out on Discord. So, because there's somebody I need to talk to, so I don't potentially kill myself. I should play Panzer Madel. What Panzer Madel? So, Godzilla versus China. I don't know who would win there. All this is because of the Tucker interview? Yeah, eventually it is. So, all right, guys. Well, that is it for tonight. We will try to get going on the next day. So Bella says locals. I'm gonna be on for like a minute or two just to check Discord to make sure it hasn't melted down, and then I'm gonna go. But we will be ready to go tomorrow, guys. We got some stuff to talk about. Like we already got some stuff out there. The Fanny's hearing that already happened and what's going to happen tomorrow. The special forces police officer who freaked out. The laundries, Brian Laundry, Gabby Petito, Brian Laundry. The deposition of Brian Laundry's father was released. And oh boy, it's kind of rough. The Kansas City parade shooting. And also a case out of Texas where the prosecutor in a small town was acting as a law clerk for the judges for over 30 years. And apparently the Fifth Circuit said that's not a big deal. So we'll talk about that and a couple other things tomorrow night. So, Bella, I'm sorry. It's turn on locals if you're going to play a pew-pews. Like I said, I'm putting this down and then I'm making sure the printer will print out what I set up for tomorrow and then we'll work on it. So I tried to keep the convo going. You did. You gave it a convo. That was a good question to ask. What I think about that? Well, like I said, I don't think it's anything to worry about. It's like Bane says, now's not the time for fear. That comes later. We'll know when it's time to be scared. So what printer again? It is a There, I put it down below. Oh yeah, Charlie, how was your blizzard? Because it was awful. Looked like shut down court. Well, it's funny by a Delta Squirrel, which is funny because that police officer was in special forces. He was a Green Beret in a previous when he was in the military. So, and he's a West Point grad apparently. So, but guys, that is it for tonight. Yeah, until tomorrow. Even if she did it, Michelle Troconis is still not guilty. At least for now. So, good night, guys. We might do a little bit of the trial tomorrow in the afternoon. And then otherwise, we will be doing the live show at 9:30 Eastern Standard Time, especially if you're new, 9:30 Eastern Standard Time. Good night, guys. Take care.